Good morning, beautiful humans. Don't mind the bizarre, weird pattern of the sun through the shade on my face. There's nothing I could do about it. The sun will move. Welcome to Defense Diaries. I'm your host, Bob Mata. Did a quick pivot this morning. I decided after the explosive direct examination of Zacahry Hughes yesterday, it's time to jump in. Better late than never. You know what they say. So we are going to be covering, if you have no idea what I'm talking about right now, we're going to be covering what they're calling the Rose Petal murder case, which I believe is out of South Carolina. The defendant is a gentleman named Zacahry Hughes. Now, Tracy, being the amazing human being that she is, and the amazing mod and everything else that she does for us, sent me a little bit of a summary of what the case is about. So I am going to go ahead and kind of whip through this. I'm going to, let me make sure, because I think this is supposed to start right around 10. So let me pull this up and it'll give Mandy time. Mandy's not in here yet. Oh, she's not in here yet. Tracy, come back. Come in the back with me, please. And thank you. All right, I'm going to pull this guy up so that it's here. Yeah, the striping's really annoying. Isn't it? It's pretty annoying. It's kind of blinding too. I need like different shades. That's what I need. That's what I need to happen. So let me pull this guy up and get it. This is going to be a hot mess, y'all, because no prep time, zero prep time. Like I wanted to be able to find if somebody in the chat knows, if somebody in the chat can let me know like an approximate timestamp or where in the direct yesterday that Hughes made that just completely insane statement about the victim sexually abusing her child and that's why, and he gets shut down. If somebody, I'd love to be able to go through that real quickly before this starts. But in the interim, I'm going to pull this up so we've got it. And then Tracy or Mandy, when you guys get back here, can you just make sure that we can cover up the do the best we can to try to cover up the logo. All right. Okay, so we got it up. When that kicks, we'll know what's up. All right, so let me go through for those who have never heard of the case, don't know anything about it. Let me go through it and let y'all know exactly what this thing is about. So the victim was Christine Parcell. Okay, so she was a South Carolina woman who was found murdered in 2021. Her body was surrounded by rose petals. Concert pianist Zacahry Hughes was charged with her murder. He and music producer John Mello, who was arrested yesterday. Tracy has also sent me the arrest warrant for that, which if we have time, I want to get into it. This case is crazy, y'all. It's crazy. We're also... so he and his music producer, John Mello, has a daughter with Parcell. We're also charged with harassment and conspiracy for sharing explicit images of Parcell. Wow. Investigators have linked the two through encrypted messages exchanged before and after the murder. Mello in a custody battle with Parcell at the time, was out of the country during the time that the crime was committed. So let's flash back to April 17th of 2021. So John Mello instructed Zacahry Hughes via WhatsApp to, quote, harass the shit out of Christina Parcell. Mello was determined to prove that Parcell and her boyfriend, Bradley Post, posed a serious threat to AM, daughter, to support his claims. He provided Zach with a trove of information to use against her. Online sex ads linked to Parcell, which Mello claimed were proof of her involvement in prostitution. Mello also handed Zach a transcript from a 2016 family court deposition in which Parcell had invoked her Fifth Amendment right when asked direct questions about prostitution and drug abuse. They exchanged 1,769 encrypted messages reflecting their close friendship. And we're talking about, again, Zach Hughes and Mello, who was arrested. Garcia's coming, Kale. Don't worry. And I'm wrapping that thing up. Happily for me. I'm over. So I want Garcia to be over so badly. But I've got another one in the can. And it's going to be over to Darren probably tonight. So that'll be, and I'm just about at trial on that. And I'm not going, like, the trial's not going to take 20 episodes. I'm going to condense it. It's going to probably be 5 episodes. I'll give openings, closings, and then the important witnesses in between. So it'll be great though. And thank you for your continued love for that particular podcast. I appreciate it. All right. So now we're going to go from April 17th to 2021 of 2021 to October 14th of 2021. So the coroner confirmed that Parcell was stabbed approximately 31 times. Zach Hughes' DNA was found under her fingernails. A ring camera was obtained from a home across the street, which also captured Hughes, quote, dressed in a black hoodie and a backpack, entering the front door of Parcell's home just before she was killed. Hughes was later seen on another ring camera, quote, leaving the subdivision on a bicycle after Parcell's unaliving. So it looked like there was a November 3rd note here, but it says document complete. So that gives us kind of a basic understanding of where we're at. And it is just a crazy case. What really kind of drew me into it was the fact that this guy's testifying, which, as avid trial watchers, you guys understand that there's an absolute Fifth Amendment right against self-incrimination. No defendant has to take the stand ever. It cannot be used against them as evidence or proof that they did something, them not testifying. I mean, if it's even mentioned by the prosecution, it should result in an automatic mistrial because it's an improper statement and it violates the Constitution. So when he gets up on the stand, which is his choice and his choice alone, lawyers can do nothing other than advise as to whether or not a defendant is going to testify. That is completely up to the defendant. Now, I've had plenty of defendants that I've tried to talk out of testifying, but some people are adamant. Oh, here it is. So Trace put it up. So November 3rd, 2021, Zach Hughes was arrested and charged with the murder, possession of a weapon during the commission of a violent crime, harassment, conspiracy, and burglary in the first degree. Thank you, Tracy. I appreciate that. So back to yesterday. So he gets on the stand. Now, I can't pretend to know anything about what was happening in terms of the motion stage of this case. I wasn't following it. So I don't know if there were motions in limine. I have to imagine that there were regarding talking about either the custody battle, the family law case that was going on between Mello and Christine Parcell, and what was brought up in that. And there must have been, I'm assuming that there was some kind of order or ruling by the judge that certain things could not be brought up at trial, because when this guy ends up testifying that she had been sexually abusing her daughter and that the state had evidence of it that they were hiding from the jury, judge just lost their mind. It's like screaming, "Shut him up!" Like telling the defense attorney to shut his client up. So it's crazy. I like I was talking about it, Allie. Allie's really under the weather, which stinks. She's not feeling well. Otherwise, she's got a terrible cough. She picked up some kind of sickness in Florida. God's waiting room, getting people sick down there. Oh, not the judge. It was the DA. The DA. Wow. All right. All right. Did anybody give me like a little bit of was anybody able to give me kind of a clue as to where in the testimony that was? I'd love to be able to kind of watch that leading up to this direct examination. Oh, it looks like they pushed it back to 10:30. All right. That's good. That's good. That gives me time. That gives me time to figure out what's up, because I want to find that. Let me see. Let me see what this is.
This jury about your oldest sister, Grace.
Yes. Thank you. I don't say.
All right, so I actually went over to over to Pretty Lies and Alibis over to Gigi's channel last night. She's been covering it pretty heavily. And I know that a lot of you have told me, hey, you really need to check out this case because it's insane. And per usual, you guys were right. It is. So I started listening, and I was listening to the beginning of his direct yesterday. And this guy, like, they're going through this whole history of that he had this life dream that he wanted to be able to perform all 32 of Beethoven's sonnets. Okay. And that he had a relationship with this church and the Wind family, I guess, or Wind Church. I don't know if that was a family or if that was the church name or if it's both. If they were going to allow him to start performing these, and he got through like a period of 3 months, he would do like 2 or 3 sonnets per performance. And so he was like into the third, he had finished the third, and then I think the following month, he ended up not doing it, which, I think lines up. It doesn't seem to line up from what I remember. So, and then I fell asleep. So they were kind of going through the background. So this appears that it's going to be him talking about his sister, him comparing the victim to his sister. So let's see what he has to say about that. I'm going to do it at 1.5 so we can hit a couple of these, just to give us the flavor. This guy was very composed on the stand. I'll tell you that. Creepily.
Say this lightly, but my oldest sister, Grace, was the most evil human being I've ever met in my life. She was 10 when she came into our family. The Russian government didn't tell us much about the kids, so we weren't aware of any, if any, behavioral issues there may have been. And there were many, but specifically with her. I would describe her without reservation as an affectionless psychopath. It wasn't that she was immoral. It was more that she was amoral. She didn't have a sense of right and wrong. Her emotional compass was seemingly non-existent. She was just dead inside. She was a masterful manipulator and deceiver. She could lie at the drop of the hat for reasons that might involve her personal gain or just for the heck of it. She would invent the most absurd, crazy, gruesome stories just to get a reaction out of people. And she could talk about this stuff with the same tone that you might talk about making a sandwich. And this from a girl that I knew between the ages of 10 to 14. It was incredibly disturbing. And the things I learned about that type of personality have stayed with me my entire life, because I've never met someone like this since. And with one exception, I had never even heard someone describe another human being like this. And one of the things that is so dangerous about someone like this is, she was literally like a vampire who would just suck the goodness out of other people around her. She could be very emotional, and she would fake these emotions in order to elicit a response in you, a sympathetic response. And if, for instance, you were accusing her of doing something like stealing or hurting one of her siblings, she would weep and just beg you to believe her and say, no, I didn't do it. And then if you would present her with irrefutable proof that we knew you had indeed done this, it was like a mask would just fall off her face. And I mean, she'd just look at you with shark eyes. And no matter how many times we would go through this cycle with her, where she would deceive us and betray our trust and hurt people in our family, she would always reel us back in, because there's something in normal, good people that wants to believe that someone like change. You want to believe that, there's redemption for someone like this, and that they might change their ways and become a better person. And she knew that. And she would use that in order to ingratiate herself again and regain our trust, only to betray that big trust again harder than she had the first time. And this happened dozens of times, and it created an incredible amount of strife in our home. She could manipulate my parents and drive a wedge between them. She was just an incredibly intelligent person and incredibly evil. And having met someone like that, it made me able to understand And even though I didn't want to accept the fact that people like this exist, whether you want to believe it or not, and if you trust them, you are only ever going to get hurt by them again. You have to forgive them at some point. And that was a very difficult thing for me to do. It took me years, but eventually I had to accept an apology from this girl that I never got and was never going to get. And I had to do it
Oh,
for
wait,
myself.
was I muted for that whole thing?
But I would never trust her again. And that would be insane, for my own safety or for the safety of others.
I was saying that he, Sonata, thank you for your radical. So as far as is it just me? Now, I have not watched his trial. Okay. But is this a little bit of the pot calling the kettle black? I mean, this guy is highly educated, clearly very articulate, obviously knowledgeable about a lot of different things. And he seems to be potentially a massive sociopath. Let's keep watching.
So this is an experience which I think most people have not met someone like this. And I mean, we might watch true crime documentaries or things like this, and we know that technically these people are real, but they exist on Netflix or in someone else's lives. And we never once believe that it could be someone we know, or that it could be someone living next door, or that it could be someone that our children play with, or, someone we might allow to look after our kids. So knowing this is essential to understanding my reaction to what John began to tell me about Christina Parcell in April and May of 2021, after Aida had been taken back to Greenville.
Wait, so Free Radical, are you saying that when he's describing his adopted sister, that he's speaking of her not as an adult, but speaking as it relates to her being a 10-year-old? So everything that we just heard is relating to not her as an adult, but as to her as a child. Wow. Confirm that, Free. Wow. I mean, look, I'm sure there exists in the world some kids that are just broken, and you know, I mean, at least in movies, you know, we've seen the movies with the evil kid. Um, that's crazy. Thank you, Free Radical. Keep flooding the chat with factoids like that, please. Or anybody that's been watching this, enlighten us, please, please. I beg you.
He started describing Christina Parcel's character and her personality. And as he was going through various points, he kept saying, Zach, I know you're not going to believe me. Like, I know this sounds blown and dramatic, and you probably think I'm exaggerating. And
Chinny, this is a great comment. I was thinking that 5 minutes ago. I was thinking, why isn't the state objecting to this whole diatribe about the comparison between his sister and the victim? How is that relevant? Like, I failed to see the relevancy. I mean, I can see the argument the defense would make. Well, you know, you have to establish his state of mind. The state of mind was born out of this comparison to his relationship with his adopted sister. You know what I mean? They make that argument. Most judges would say, nah, that's not relevant. So it's kind of, it's interesting. It's interesting.
under other circumstances, I would have, because John does, I mean, he's a big storyteller. And, you know, when people are talking about their exes, like, everyone thinks their ex is the Antichrist. So, of course, I was sort of predisposed to be biased against what he was telling me, except for the fact that point by point, everything he described about Christina Parcell was exactly the same as my sister Grace. He told me that Christina Parcell was a master manipulator. He said she can lie at the drop of the hat and you'll never know it. He said she was incredibly charming. He said she was incredibly intelligent and talented. He used to say she was smarter than he was, but that her biggest fault was that she was lazy. And she had this arrogance combined with her laziness that was essentially born out of the fact that she knew she never really had to work too hard at anything in life. And she could even sacrifice trust with people and tell them lies that could easily be found out, because ultimately she was completely confident in her ability to reel someone back in, no matter how bad she had burned them before. And he could have been describing Grace to me because I knew this behavior. I had lived through this behavior. So at this point,
I'm sorry. When he was describing these features to you of Christina, had you ever told him about Grace? Did he know anything about Grace?
no, I don't make a habit of talking about Grace to people. One, it's incredibly difficult to speak about. And two, most people, having not met someone like that, it just doesn't really land most of the time. They don't understand what you're talking about. So no, John had no idea that I'd had this experience with Grace, which made me realize that there was no way he could have possibly invented this, because no one would get it right point by point by point unless they had met one of these people. It was the first thing that really raised a huge red flag with me and made me think that despite the fact that he can exaggerate and overblow the truth, and he's often not very believable when you listen to him, I was convinced at that point that he must be describing something true, because no one would know how to describe it so specifically and accurately if they were just making it up. And I was right to believe him. So in addition to this description of her character, and one last thing about Grace and Christina by correlation, one thing Grace was she had an addiction to doing was not merely stealing from you or sucker punching one of her siblings just to assert dominance or doing other terrible things to her siblings. She would recruit her other younger siblings to do these things for her. She would get off on making little duplicates of herself and training and enlisting her siblings to act as proxies for her, so that she wouldn't actually get in trouble, because she knew that we all had our eyes on her because of her behavior and we knew we couldn't trust her. So if she even had 2 minutes with one of her younger siblings where no one was within earshot, she would tell them, hey, mom's going to go check the mail. I just saw the mail truck go. When she's doing that, I want you to go run into her bedroom and go into her jewelry, or go and get this for me and we'll split it. Go and get that food that mom said we can't have till the weekend or something. So she was an incredibly corrupting influence on anyone around her that she could exert her influence on. Again, or a vampire who sucks the goodness out of others. This is an incredibly appropriate metaphor because that's what vampires do. They're intelligent, they're dead inside, and they eventually kill the people around them unless they find someone who might be useful to them, and then they create a duplicate of themselves that they can control. And this is exactly what Grace would do. So when John was telling me all this, I realized that there was an incredible danger.
I caught myself that time. I almost started talking again on mute. So is he talking about Grace when she's 10? That this kid is some kind of evil mastermind that can manipulate adults to do her bidding? I mean, is that what I'm hearing? Y'all got to tell me in the chat. Like, that, man, I should have watched this trial. This is fascinating. This is fascinating. Absolutely fascinating. I mean, look, I immediately thought, look, sociopaths can be incredibly engaging and incredibly articulate and incredibly convincing. You know, I see Akasha saying, I believe this guy 100%. I mean, I could see why. Like, this seems incredibly genuine. Wow, this is crazy. All right, I'm keeping an eye on the trial, by the way. It's showing about 6 minutes.
What Christina Parcell was a future preview of what Aida Mello could potentially become if she was left in this woman's custody and was raised by her. And the facts have borne out that I was right. But
Sustained. We'll instruct the jury to disregard the last comment.
Zach, at some point, was Grace actually removed from your family?
yes,
Describe for this jury why, or the circumstance or the event that prompted.
I mean, he's not talking about Natalia Grace, is he? Like, was it Natalia Grace was the one with the little girl that they didn't know if she was actually the little person who they didn't know if she was 20 or 30. They're not talking about her, right? That's just coincidence. I'm assuming that's just coincidence, right?
Her removal from your family.
it had been 4 years of what I'm describing. She had been sent to different girls' homes around the country, many of which had records of never expelling a single student, and she was the first for many of them that they expelled and sent back to us. And it finally just got so bad that we realized she was going to be a physical danger to our family. I discovered a diary that she had made where she described in detail my parents having their eyes gouged out and dying, and how once my parents were out of the way and dead, she would be able to assume her role as rightful queen of the country. So she just had these psychopathic delusions of violence and grandeur. The SS and asked them to remove her from the home.
We're going to come back to that in a second, or in a little while. You testified about things that John told you about Christina. Did he also provide you with other information about Christina that informed your opinion of her or what you came to know about her?
Yes.
What were some of the documents or other pieces of information that John provided you with?
No objection, hearsay.
No, we're not offering it for its truth. We're offering it to show what he knew. It's A versus Vic outside your Honor. We're not offering it for its truth. Go ahead.
He offered me, among other things, three
Wow.
very pertinent collections of information. One was the photographs that have been discussed that I sent in mailings to various people, along with advertisements from an escort website, which were connected with these photographs. These photographs were of Christina Parcell in various stages of undress.
So the one thing that I did hear as to Laura's point here, where she says, I think it's wrong that he cannot talk about the deceased being an abuser. I know that there was a lengthy, I don't know if it was a sidebar or motion in limine regarding that exact issue. So, because typically I would agree, but I know that they were trying to put forth the defense of another, which is an affirmative defense. And in that situation, if the judge allows you to move forward with the defense of another, meaning that he felt that he did what he had to do in order to protect that child, and that ultimately resulted in in what happened to Christine Parcells. So, but it sounds like that was denied, that they weren't allowed to put that defense forward. Had that been approved, then he would have had to have established this pattern or the behavior that he says made him knowledgeable as to the risk that she posed to the child. So, but once that was shut down, I think that's why the judge is limiting what he's able to say, which, I mean, if he's convicted, that's certainly going to be an issue for appeal. I can tell you that. But wow, yeah, this is something else. I feel like I gotta go back. I agree. I think Catherine was saying, Kathy said, I wanted to go back and watch the whole thing. Yeah, I feel the same way, Kathy. And thank you so much for your generosity, by the way. And you too, Afton. And then Melanie had asked Bob, the defense deferred its opening statement until after the state rested. I have never done that. Allison and I contemplated it a few times, but that concept of, unless, like the only time that we ever really, really contemplated is if we knew it was going to be a relatively short trial. I think it's a huge risk taking the position that we're going to reserve our opening until we start our case in chief, because you're just allowing the state's narrative to be the only thing that the jury hears throughout the beginning of the entirety of the case. And if it's a long case, that's scary to me. It's like I always worry as a defense attorney having to go second anyway, because you always worry that the state, if the lawyer is compelling and their narrative is compelling, that the jury's going to lock in on it and you're not going to be able to change their mind. Y'all know, forget about the law, forget about cases, just think about anything that you formed an opinion on and think about how hard it is to change your opinion about that thing. It's no different in a trial. So no, I've always felt that we need to get our narrative out there if we have one in a particular case. Because remember, every defense, they don't have a narrative. Some cases they just don't have the evidence. They can't prove that our client did that. That's not necessarily a narrative. Other cases have, okay, well, that's not what happened. This is what happened. So I mean, it's two different types of cases, but yeah, no, like, yeah, in my opinion, you got to get it out there at the forefront. And then you've also got to remind that jury to please do the best that you can to try to reserve your opinion on what happened here until you hear the entire case, where you've heard both the state and the defense's case in chief. All right. This clip's about wrapped.
And John told me that they were prostitution advertisements from her previous career as a prostitute. And looking at these photographs, there was no doubt in my mind that that's what these were. And I don't say this in any way to try to shame. It's simply that, I mean, who said it? Like pornography, you know it when you see it. Well, I think the same can be said in terms of
Supreme
these
Court of the
photographs.
United States said that.
They were not cute, sexy, intimate photographs that someone might send to someone they're dating or something. They were lewd and tasteless, and there was a very clear element of advertising, a commercial element. So when I looked at these, there was a vacant, arrogant, almost derisive look in her eyes that reminded me so much of my sister. It was a look that said, I can get you to do whatever I want because you want what I have to offer you. And coupled with this was a deposition from 2016 that Christina Petal had given.
1 second, Zach. Let me show you, Zach, what's in March's defense exhibit 46. Take a look at this.
Wow.
Yes, this is the deposition.
All right, this time the defense removed defense exhibit 46 in evidence
Shoo.
in October of 2021. Remember that?
Yes.
And Zach,
All right, I'm still keeping an eye on it. This is a much longer clip. I'm going to kick it up to 1.5. This clip is where he's making the admission of what he did. Let's see how much of it we can make through. Well, I'll see if 1.5 sounds crazy. It might. He's slow. He's a slow talker, so he might not sound too crazy.
you testified before lunch about 2 offers John had made you to kill Christina Parcell. Do you remember that?
I remember.
And do you remember after the second offer telling John something to the effect of, you would never do that for money. You would only do that if you believed it was necessary to rescue Aida.
And if I believed there was no other way.
At the end of September, beginning of October, 2021.
All right, so Lisa's got Lisa, I cannot believe. Everybody talks about Garcia, but Gacy is legend. I'm so proud of that podcast. And it's all scripted. I cannot believe you haven't listened to my podcast. That's insane to me. Insane. Forget about the chat. Like when you're driving, you can't chat. You can't chat and drive, Lisa. I'm going to start, like, Lisa, you specifically, I'm going to quiz you on Gacy starting next week. There's 36 episodes. It better be one kind, just one hell of a road trip because it's a really long podcast. So here's what I want to ask. And again, I've got zero background on this case, so I'm not going to assume anything. But I've seen a comment. Did this come into evidence? Somebody said that Melanie said that the police found thousands of pictures and movies of Christina harming her daughter and animals. All right. So did that come into evidence, or is that rumor, or is that something that, I mean, is that out there as being a fact, or is that just something that people say? Like, did that come into trial? And I'm gonna pose this question to y'all, and I'd love to see your answers in the chat. If that's the case, if that is in fact the case, if those are actual facts, that there are thousands of pictures and videos of her abusing the child, especially the child, animals is obviously horrible. You guys know I'm a pet lover, so that's disgusting as well. But in terms of this case, does that sway your opinion? I mean, like, does that turn him into a vigilante? If he has been denied the opportunity to come forward with the defense of others' defense, obviously the judge had heard substantial argument on that, and the judge did not feel that they met their burden in order to bring that defense forward. So I've got to weigh that. Like, I've got to go back and watch this whole damn trial. I'm fascinated. I'm like completely dug in, but I'd like to know, because if that defense has been said by the judge, can't bring it in, I'm not allowing it, the jury's not going to be able to consider that. So then we're looking at a situation where you'd have to have a jury nullification if he's able to get enough evidence in that the victim was in fact abusing her child to the extent that this person felt that it was warranted to end her life. I mean, we don't live in a vigilante society. It's not how the law operates. It's not okay. I mean, look, I've got 4 kids. If somebody did something to one of my kids, I cannot say what I would do or would not do. But if I did the unthinkable to somebody who harmed one of my children, I'd do the time for it. You know? I mean, if I decided to take the law into my own hands, I'd do the time for it. I mean, that's how this thing works, y'all. So, but let me know in the chat. I'm interested to see what you guys think.
Did you conclude that you had to rescue Aida and there was no other way?
Yes, I did.
Let's talk about what's happening in your life in the beginning of October 2021. And specifically, I want to talk about the status of the music project you have been engaged with Tom Strange in the Seagull Museum. I also want to talk about other employment opportunities. So tell the jury what was going on in your life on that front at the beginning of October.
At the beginning of October, I was just coming off finishing the project at the museum. We finished in September at some point. And as I mentioned before, my birthday is October 2nd. So I had arranged to play a private home recital at the Wynn's home, where I would play the last 3 piano sonatas of Beethoven on my birthday. So these are very, very difficult pieces of music, and some of the greatest pieces of music ever written. So I was very preoccupied trying to give my best to these pieces. And shortly after that, a friend of mine reached out who had done some work performing on cruise ships. There's an organization called Lincoln Center Stage that recruits conservatory trained musicians to form either a piano quartet or a piano quintet to play classical concerts on cruise ships. And they had a pianist drop out at the last minute. And long story short, I interviewed for this job and got this job, I think on October 12th, but it was about that time, maybe a little earlier.
Where were the winds on October 12th and 13th?
They were in Europe.
And ultimately, did you take Christina Parcells' life on October the 13th?
Yes, because I believed it was absolutely necessary to save Aida, and I was right.
Objection, Your Honor. Sustained. I ask you to disregard the testimony that you just heard.
Wow.
I want to talk about the timing.
There's no unringing that bell though, right? You know, I mean, judges try to give that admonishment all the time. I want you to disregard that. You know, I mean, once something comes out of somebody's mouth, it's in the jury's brain. I mean, let's be real about it. You know, I mean, it's like, it's typically the lawyer that's doing it more than the defendant on the stand where they're saying something. Oh my God. I am, hey, what's up, Sleuth? Welcome, brother. Yeah, I'd like to know this. Does he have any violence in his past? Man, I am fascinated by this case, and I've only just begun. All right, and I am keeping an eye on it. We still have got the South Carolina state crest or state seal rather on the wall, so they have not started. So let's keep plugging through this.
You've alluded to it a little bit, but I want to be more specific. October the 13th, describe for the jury why you felt that was the time, why it was necessary to do it on October the 13th, specifically in this period of time.
I had been wrestling with this since June. As I previously stated, since the end of June, I believed Aida was in complete and grave danger every moment of her life that she was living with her mother. And the other things that I had tried to do to save her from that were not working. So I was having this incredible wrestling match within myself for these months, feeling that I needed to do something to save her, and yet feeling this incredible reluctance to do the one thing that I knew would save her because of how terrible I knew it would be to do it, even though I believed it would be right. So by the time October 13th rolled around, I had been grappling with this for a long time, and I was experiencing a tremendous amount of guilt that I had waited as long as I did because I should have acted sooner, and I didn't do that. So I had come.
All right. So I like Free Radicals' comment here. I don't know why people think it's okay for this creep to stab someone to death because that person did bad things. Yes, they must face justice. This guy doesn't get to decide justice. It's not his child. I think that's a huge point. Like in the cases that you've seen historically, where you've got that situation where I was talking about, God forbid, somebody ever did something to one of my children, I don't know how I'd react. I have an idea, but I don't know. You know, and like I said, but that's a different situation. It's my blood. It's my child. Like my number one role on this planet is to protect my children. There's nothing that I care about more than that. I would take a bullet without thinking about it. I'd step in front of a tray. I'd give my life up in a heartbeat for any one of my kids. This guy ain't that guy. You know what I'm saying? Like this by proxy shit doesn't work. That's not what this is. We don't live in that world. You know, and I can see what the counter argument's going to be, but Child Protective Services has failed this child. This child was at peril. They had Mello like pegged as the crazy one in the relationship. He was the bad parent. She was hoodwinking the system. I've seen that firsthand from both sides in some family law cases that I've handled over the years. I mean, there is without question, people use the statutes, the family law statutes, and the domestic violence statutes and the TRO, temporary restraining orders, or injunctive orders as swords as opposed to shields, especially in custody cases where it's explosive. I mean, there was a case in Kane County. I want to make sure before I start getting too long-winded, which, you know, we're on. All right, hold on. Remind me to tell you, there was a crazy case in my county. All right, so we'll come back to that. It looks like we're getting ready to get started today. So let me switch this up. I don't know about y'all, but I have definitely seen enough to really want to watch this. So, all right. So this is live right now, I believe. Wait. Oh, wait. No, God, that's day 6. I'm screwing up, y'all. I'm making terrible, terrible mistakes. Let me see. Okay, wait. Oh yeah, it's still the state seal. All right, so I close that one out. All right, I'm live on this one. I've got it up. All right, so there was a case, and I saw somebody talking about a guardian. I'm assuming that you're talking about the guardian ad litem. If you guys don't know what a guardian ad litem is, typically they're attorneys. Like in our state, they're all attorneys. So if you have a custody battle going on, and each of the parents, even if one's pro se and one has an attorney, or if both have attorneys, obviously those attorneys are representing their clients, that being mom and dad. Who is not represented in those matters are the children. So that is when you have a guardian ad litem appointed. Their only job is to protect the interests of the child and to do what is in the best interest of the child. The guardian ad litems then conduct an investigation if there is a custody fight, because the judge knows nothing sitting on the bench. They don't independently know who these people are. I mean, I would tell my clients all the time in divorce cases, especially when there were children involved, I'm like, it is in your best interest to come to an agreement, to act like adults, to realize it's the kids that matter, not y'all. Y'all are going to survive it. Be grown-ups. You'll survive the ending of the relationship. Realize that you need to make this as soft as a landing as possible for your children. And don't talk shit about one another. because your blood, each of your blood courses through the veins of those kids. So all you're doing is hurting your child when you're talking shit about, again, I don't care how much you hate that person. Be bigger than that. Care about your children more than that. So the GALs will come in, they'll do the investigations. Some are great, just like anything in life. Some are phenomenal, some are awful. Some never leave their desk. Some do surprise home visits. I always would just bug the hell out of GALs. I'm like, okay, don't give the parent, no matter which side it was, because I always cared about the kids in a divorce situation. Yes, I would represent my client to the best of my ability, but the concern was always the children, because those are the ones that we need to take care of in a divorce situation. So, but I would say you have to do surprise visits. If you give somebody advance notice that you're coming to their home, you're going to get the best behavior bullshit. That is not real life. I'd always say, hey, when you walked in, did you see fresh vacuuming tracks? Did the person clean up that? Like, you want to see the parenting in its natural state by surprising them. That's how you start to get a real idea of what's going on in a household. And you also need a GAL who can really build a rapport with a child, because that is an incredibly awkward situation to be in as a guardian ad litem, where you're dipping into this child's life. They have no idea who you are, and you're asking very personal questions, and you've got to try to build up to that, to where you're hoping that the child trusts you enough in order to give you truthful answers about what's going on in that child's life. And it's a delicate balance. So, but like I saw that was apparently, there was a GAL in this case, I'm assuming, because it was a very highly contested custody fight. It sounds like it was like lots of mud was being slung. So in that type of case, I do not, I feel bad for the GAL, unless the GAL sucked. And believe me, there are awful GALs that exist out there. People that are just mailing it in, not doing the work, that they don't care. They're just getting paid by the court or the parties, one of the two. Typically, the parties have to split the GAL's bill. And, that is not helping the kids by mailing it in. So at any rate, there was a case in it crept into social media, because it was the husband and wife. It was in the county that I practice most. And somebody made me, one of my friends, a fellow attorney, was telling me about it. He's like, man, have you heard the rumors about this? You heard about this case that's going on? And I'm like, no. He's like, oh man, he's like, just jump online. So it turns out that in this case, they were just gaslighting the shit out of the woman, out of the mom, saying she's nuts, she's crazy. And they're like, and I am here to tell you, once you are portrayed as that in a court of law, and once a judge has once again reached an opinion that this person is unhinged for whatever reason, it is very, very difficult to be able to change that judge's mind. And then it starts getting piled in. Like if you've got a client on the other side that's super compelling, that's super believable, and they're saying, man, this is what this woman's been doing. So this huge battle's going on. This guy, this guy was coming into court, and the GAL had been hoodwinked. And I say hoodwinked because of the end result of what happens here, and just thinking that the mom was not right, that she had mental illness, she had issues, and ultimately they end up giving full custody to dad. And in the meantime, the woman, the mother, starts this social media campaign just blasting the judge on Facebook, blasting the GAL, calling them out, like stating facts, which only served in that circumstance. Looks like we're getting ready to roll, to lock in the judge's opinion that this woman was unhinged. End of the story. Within 3 weeks of the child moving in with their father, the child ended up dead. All right, I'm gonna pull it up.
Sorry that I have to send y'all in and out, okay? All right, anything further?
Nothing further, the defense rests.
Defense rest.
Defense
Okay,
rest.
Ladies and gentlemen, you can go back to the jury room.
Wait, where's the cross examination? Was there a cross? Wait, is this today? Hold on. All right, wait a second here. Holy shit. Wait, all right, so this is all I see. That'll be disappointing. That'll be disappointing. So it looks like there's like 8 minutes here. All right, they haven't turned the like what? Okay, that's on me. There's no sound on this. I'm super far behind on the chat. Why is there no sound here? What the hell's going on? There we go.
There's State's Exhibit 66 up there on the overhead. Mr. Hughes, when you dragged Christina Parcell across the floor of the front room where you killed her, did you drag her by her arm or by her ankle?
I don't remember for certain, but I think by the ankle.
That's all the questions I need to ask this, Your Honor.
Is that the cross examination?
No redirect, Your Honor.
All right. Y'all tell me in the chat, did the cross start yesterday? Or is that it? Is that the whole cross right there? Wow. All right, I'm going all the way to the bottom of the chat. So that's it. Wow. Wow. That is stunning. I mean, he sat up there for hours and just gave narratives. Wow. Wait, EB, no cross yesterday, or no, he was crossed yesterday? Can you clarify that? Yeah, I remember that. I was talking about that, Hedgehog. I was like, you and a few other people were like, I got to pick this case up. Wow. All right. I mean, so the defense is now rested. Wow. All right. So All right, here's what we'll do. Let me figure out what they're going to do now. I'm sure the defense is going to make a motion for directed finding. And then we'll go back, Anne Marie, and I want to watch the last 5 minutes of his testimony yesterday.
Welcome back. Just be patient and understand there are procedures.
Bloop, 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 bloop. All right, so. Oh, what the hell? Are we not going to get to hear the motion for directed finding? Is Gigi in the courtroom down there? She's got to be. She's got to be. I got to text her. Wow. Okay, so I'm going to get live and then I will flip over to yesterday. All right. Wow, that's stunning to me. I mean, somebody said, well, what could they ask if everything he said was true? It's a valid point. It's a valid point. Wow. All right, so looks like it might be closings. I don't know if there's going to be a rebuttal case. I don't know if there's going to be. So 12:30. What time is it now? 12:30 Central. Oof. All right, so here's what we'll do. I'm going to watch a little bit. So they're taking a break. Thank you for that intel, Audra. I appreciate it. We'll watch a little. Let's watch a little bit more of the testimony tomorrow. And does anybody know if there's going to be a rebuttal? What was yesterday? Kasha. Oh, you're saying, wait, what was yesterday? Motion for directed finding? Oh, after the state rested. Okay. Yeah, that makes sense. Was he the only witness? Was he the only witness for the defense? No rebuttal. So we're going to closing arguments. Wow. Okay. Okay. All right. So let's watch a little bit more of yesterday's testimony. I'll probably shut this stream down, or y'all let me know. I can leave it open so you can hang in the chat, or I can create another one, and then just when they come back, we can come back. You guys just let me know. But in the meantime, let's go back and okay. So I don't know. All right, y'all tell me in the chat. Is this so? This particular clip runs about. It's 35 minutes long. We're about 6 minutes in. The one that we were just listening to, and I'm curious. Please tell me in the chat if this is the end of his direct, because this is where he admits to the crime. Oh, shit. Sorry, guys. Oopsies. Tech wizardry. Tech wizardry.
Did you get a gun?
Yes.
At the time, were you also carrying your own firearm?
Yes, I had a concealed weapons permit at the time, so I generally would always be carrying a 9mm concealed weapon on my person for personal protection.
Did you get another firearm for this?
Yes, I did.
What type of firearm did you get?
It was a .22 caliber revolver
Where did you get it?
at a gun show.
Where was the gun show?
It was here in Greenville.
How long before October 13th did you get the 22?
Maybe a month or month and a half earlier.
Did you also get a knife?
Yes, I did.
Where did you get the knife?
At the gun show.
At about the same time?
It was the same day.
Let's talk about what else, what other planning you did. Did you obtain gloves?
Yes, I did.
Do you remember where you got the gloves?
No, I don't.
Did you obtain any chemicals?
Yes, I bought some paint thinner because, again, I didn't want to be connected to this because I wanted to make sure this would actually do something to save Aida. So in case a glove had broken or I had left a fingerprint or something, I wanted to be able to clean it with the paint thinner.
Zach, let's talk about your bike and what you did to become familiar with the area of Canebrake leading up to October the 13th.
I had looked at a route I would be able to take from the mountain house that I was staying at on back roads to avoid traffic cameras. So maybe a few days beforehand, I looked at Google Maps and I figured out how this route would lead.
Let's talk about October the 12th. Did you originally plan to do this on October the 12th?
Yes.
Zach, consistent with the court's instructions, describe to the jury why you didn't do it on October the 12th.
I woke up that day and I just felt such reluctance and something in my gut told me it wasn't the right day. And I waited one more day.
Let's go to October the 13th. You testified earlier that you wanted to plan in part to prevent or minimize danger to others. Remember that?
Yes, I do.
Did you have information about where people would be on October the 13th?
To a degree, yes.
How did you get that information?
From John Miller.
What did he tell you?
He told me when Aida would be at school, and he told me that he believed Christina had a job interview at some point that morning.
So let's talk about that morning. The evening of October the 12th, where did you spend the night?
At the mountain house.
You woke up on the morning of October 13th and you left the mountain house, is that correct?
Yes, it is.
Do you remember approximately when you left the mountain house?
It was much later than I meant to. I think it was about 8 or 8:15 in the morning.
When you left the mountain house, in which vehicle did you leave?
In my Ford Ranger.
What was in the back of the Ford Ranger?
My bike.
That bike right there?
Yes.
And just for the clarity of the record. This is a state exhibit. I don't have the number that was in the booth. What else did you put in your pickup truck in addition to the bike?
I brought gloves and I put this in a backpack. I brought the paint thinner and the gun I described, the .22. I brought a knife and I brought a box that was made to look like a gift wrapped box and a bunch of roses that I had bought the day before.
Talk about the roses in a minute. When you left the mountain house, where did you go?
I drove to a road that runs parallel very close to Canebrake.
when you got to that location, well, before we go further, describe for this jury the ride in your truck from the mountain house to this location, what you were thinking, what you were feeling, what was going through your mind.
Like I said, I had wrestled with this for months. I had come to the point where rationally I knew that the only way Aida was going to be saved from what she was enduring was for me to take this route. I knew that. But there's another element, a human element, which is just so reluctant and revulsed by the idea of taking a human life. So I had prayed a great deal about this. I had prayed like I'd never prayed before, because even knowing that logically this was the right thing to do, it didn't satisfy that emotional and human aspect where I felt that I needed permission to do this. And I was so terrified that somehow I might be doing the wrong thing. Like I knew that it was right logically, but there's the emotional aspect was just reeling against this idea. And more so because she was a woman. I was raised to always protect my sisters and mother, and I opened doors for women growing up. So this idea was just repugnant to me, even though I believed it was necessary to save a child. So on that morning, I had prayed a few days earlier, and I had felt that this was the right thing to do, no matter how terrible and difficult it was going to be. So like I said, I didn't feel anger. I felt pity because I realized that this was just the only way to save a child. And it felt like a foregone conclusion because I knew that I had a duty to do this to save a child. So physically driving my truck there, I was experiencing a level of anxiety and physical illness that I had just never experienced due to stress before. My hands were shaking. I was in a cold sweat, and I was fighting the urge to vomit before I even got close there. A few times I thought I was going to have to pull off to the side of the road because I could hardly keep my truck straight. My hands were shaking so badly. But the whole time,
Just to be clear, I didn't say that I'd be a great cult leader. I was reading a comment from that B. Kramer guy who's I think he's from the murder sheet camp or whatever. He was saying that. I was reading his comment out loud because I thought it was pretty hilarious. Just clarify.
I was just thinking, if I don't do this, if I turn back, then I'm consigning Aida to her fate when I know that I could have done something to stop what was happening. So I just tried to take my mind off of it, and I tried to just go and drive a little bit farther and not think about what I was going to have to do when I got there. And when I finally got to the point where I parked my truck, this feeling only increased. I knew the plan, but I was having so much difficulty going through with it. So I took my bike out of the truck, and I had a mask on and clothing that's been described already. And I just tried to focus on putting one foot in front of the other on my bike. And it felt like some runs or rucks I had been on where all I could do was focus on putting one foot in front of the other because it was so difficult to keep going. And I just kept seeing Aida's face and reminding myself that if I don't do this, no one's going to come to save her. And I kept pedaling, and eventually I arrived in front of 122 Canebrake.
Zach, we're going to talk about what happened when we got to 122 Canebrake in just a second. You described having a gun and having a knife. Initially, were you going to use the gun?
Yes.
Did you ultimately decide to use the gun?
No.
Why not?
I was very concerned about using a gun because of how loud it would be. And I didn't want to alert a neighbor or a bystander who might come to investigate and get involved. So I tried to suppress the gun by making a makeshift suppressor. And in movies, these things are made out to be like it's very easy, and a suppressed gun is just very silent. And that's not the case. So ultimately, I test fired the gun, and I had bought some subsonic ammunition, which is supposed to be quieter, but I didn't realize that on a revolver, the suppressor doesn't work because the end of the cylinder is open. And I realized just a day or two beforehand that I couldn't use a gun because it could potentially involve someone else in this if someone heard a gunshot and came to investigate.
If you had a choice, would you have rather used a gun?
I would have rather not have had to have done it at all. But if I had to, yes, I would have chosen a gun
Why is that?
because it would have been quicker and more humane.
All right, let's talk about you arrive at the house. 122 Canebrake. Do you remember about what time you arrived there?
I think it was a little after 9 in the morning.
And you arrived there on your bike.
Yes.
And you testified about this a little bit, but tell the jury what you're wearing.
I had on black pants and a black thermal and a gray shirt over that. I had on a black beanie and a white medical mask, and I had on black gloves and a black backpack.
Do you remember how many vehicles were parked in the driveway when you got there?
One,
When you arrived at the house and you got off your bike, what did you do?
I laid my bike down in the driveway, and I took my backpack off, and I took out the box that had been gift wrapped that had an end open, and I put the .22 revolver in that box. And I put the backpack back on my back, and I took a bunch of roses, and I walked up to the door, and I rang the doorbell. And I was shaking and freaking out at this point because there was nowhere I wanted to be less than at that house on that morning. And when I rang the doorbell, the door opened and a woman came to the front. And I thought it was Christina Parcell, but I wanted to make sure. And I also wanted to make sure that no one else was home. So I told her that while I was holding the box and the roses, that I had a delivery for Lutina Parcell, her sister. And she told me that Lutina wasn't home. So at this point, I realized that Christina was at the house alone. And I handed her the roses. And I took the revolver out of the box and I pointed it at her. And I told her to be quiet and to go back into the house, which she did. And I followed her into the house and I shut the door. And I was experiencing such anxiety that my body wasn't really doing what I was telling it to do anymore. Like when I realized that I couldn't use the gun, which was unloaded at this point, my plan had been to try to knock her unconscious because I didn't want to cause her or anyone any pain. That wasn't my intention. I just wanted to save Aida and to make sure that no one else who was a bystander would be involved in this or could be endangered in any way. So I tried, while she was holding the roses, to strike her on the head and knock her unconscious. But my body was fighting me because even though I knew who she was and what she was doing and the danger that was putting Aida in, I was still looking at her and I was seeing a sympathetic figure. I was seeing a woman, and I had always been taught never to hurt a woman, to always protect women and children. So when I went to strike her with the gun, my hand didn't really do what I was trying to tell it to. I essentially pulled my strike. It felt like a time I had been cliff jumping with friends. I have a big fear of heights, and there was a 30-foot face that you could jump off and jump into a deep pool of water. And when I would run up to the edge, I would try to get a running start and jump off the edge, and I just couldn't. Like my body would stop me against my will. And I had to try to do this 10 or 15 or 20 times before I could actually get myself to go over the edge. So
Bob, you're muted.
Ugh. 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 See, it's because I use the cough button. I'm polite. I don't want to be coughing in your all ear. So I hit the mute button Like thank you. That was amazing. Like, I'm so glad that Allie put that thing on there. Like, I would have probably talked for 7-8 minutes. So, but I was giving an explanation of what a directed verdict is. They call it either a motion for a directed verdict, motion for directed finding. Essentially what it is after the state's case in chief is done, the defense will stand up, they'll make an oral motion, they'll say, Your Honor, we'd like to make a motion for a directed finding, and we don't believe that the state has met their burden. Now, remember, for each crime that is charged, the state has to prove each and every element of a crime. Now, if you watch our channel frequently, we've gone through statutes many, many times with you. There's many elements in almost every crime that's committed. You know, there's multiple elements in homicide. You have to prove that the person was alive. You have to prove that they were killed. You have to prove that it was an intentional homicide. You know, so those are all elements, and they're all separate. And the state has to prove each and every one of those. So in cases where the defense doesn't, in every defense lawyer is always going to make the motion, because it's ineffective assistance of counsel if you don't, and you waive the issue for appeal. Just remember that. I mean, a lot of the things that you see during trials are done because of the appellate process. You always have to preserve issues for appeal. So, you know, the defense will make the argument. I've never had a judge dismiss a case, or it's not even dismissing it. They're literally coming back with a not guilty finding if they're granting that motion. It's not like, oh, we dismiss the case. It's like, oh no, okay, I agree. The state did not meet its burden. I'm giving a directed finding of not guilty. That means that it doesn't even need to go to the jury. It's similar to what they call a motion for summary judgment, which they have in civil cases. The difference being there, if you don't believe that the plaintiff in a civil case has either made their case in their complaint, that what they've stated in their complaint doesn't even rise to the level of being a case that needs to be litigated, or in the event that they think that, or they're arguing that there are no issues of fact, that there are only issues of law. Remember, issues of law are decided by a judge. Issues of fact are determined by the fact finder. So in a case, a civil case where you have a motion for summary judgment, and one of the parties says, okay, we're filing for summary judgment here because this case doesn't need to go to a jury. There are no disputes as to the facts. There's no facts at issue. This is merely a legal argument, and your judge, your honor, can decide that. So the judge will read through it. If the judge agrees, they'll grant summary judgment. Thing goes away. Case is over. If the judge doesn't agree, then it goes to trial. So this is kind of similar to that, but different. But it's the same concept. It's a way that you're asking the judge to rule on the law, but the judge is making a gut call on whether or not the state has met their burden. 99% of the time, maybe even 99.9% of the time, the judge is going to let it go to the jury. Like Alice and I always make the motions. We've won on counts, meaning that if it's a multiple count indictment, we've had the situation where the judge has said, okay, well, they didn't meet the burden on count 2 and 3. I'm going to grant your motion on directed finding as to those, but the rest is going to the jury. So the judge can cherry pick particular counts if they don't feel that the state has met their burden. So we've won some of those, but we've never had a judge just end the case on a motion for directed finding. They're basically denied pro forma. So that's what that is. I just wanted to answer that question.
When I struck her on the head with the pistol, that's what happened. It didn't knock her unconscious, and I'd hardly struck her at all, to be honest. So I tried again, and the same thing happened. I just couldn't bring myself to strike her. And at this point, she realized that I was hesitating, and she began to try to move herself and to get away and to fight back. And during this period of time, the roses had dropped and the petals and stems had scattered. And as I was hesitating, I realized that the situation was quickly getting out of control. And if I didn't pull myself together and act soon, this was all going to end up terribly for Aida, because what was happening to her would never be uncovered.
Just a quick question. You've heard testimony that at this time, Christina weighed 163 pounds. How much did you weigh on October 13th?
About 160.
Go ahead.
So I realized that I was going to have to somehow force myself to do this at any cost. So I pulled out the knife I was wearing. And even though I knew I wasn't going to be able to strike her with any amount of force, I still tried. So I started striking her, though my strikes were pulled. And I think the knife made contact with her, but it wasn't stopping her, and it wasn't inflicting anything that could be a fatal blow. And she started to fight back. She realized I was hesitating, and it became a struggle. And in the struggle, all I could do was try to overcome this resistance I had towards doing this thing. Even though I knew it was right, I still had this physical and emotional resistance to doing it.
She did.
So I just kept striking her until finally we fell on the floor. And at this point, I had just tried to take my mind out of it and just try to get through this and finish it as quickly as possible, because I realized that it was only becoming prolonged.
All right, so I want to address Brittany's comment here. Baby, I hope they find him not guilty. I really do. You've got to think that all the way through. Okay, so we're forbidden as defense attorneys from ever arguing for jury nullification. We cannot, because what you're asking the jury to do is ignore the law. Huge no-no. Can't do it. Not allowed. And here, and I think somebody said that Josh did a nice recap of why the argument for defense of others, why they were denied being able to put forward that defense. Maybe I'll throw that up and check that out. I'll text Josh and see if he's cool with it. I'm sure he will be. But to Brittany's point, we are living in a much different world if people are allowed to take the law into their own hands. And I get the argument. I get that the system failed this child. I get it based on what people are saying. I have not seen all the facts. I'm going to always preface it by that. I have not. I'm taking your word on stuff, a lot of you guys, and I'm sure that you're giving me excellent information. So, but we just can't start doing that. And beyond that, this guy wasn't the kid's father. I have to be honest, of the little I've seen of this guy, I don't feel comfortable having this guy walking around acquitted on this thing, thinking that's the kind of shit that he's going to do, because the next thing he's going to do is go home, create some kind of superhero costume, and start creeping around at night, taking the law into his own hands. This is that guy. This is that guy. If you can't tell from this testimony, this is that guy. And he comes off, he's very articulate. He is selling the hell out of this. But the fact of the matter is, he can't do it, y'all. He can't do it. Can't. It's like, Melanie, that means that everybody on the planet, well, forget the planet, anybody in our country that thinks that somebody else is in peril that they're not related to can now just take the law into their own hands and end that person. They are now acting as judge, jury, and executioner. That is scary to me. I mean, that's like the old West, the Wild West. Ah, you're cheating in a hand of poker. I'm going to pull my gun out and shoot you. While I understand the sentiment, if in fact this child was being abused, we cannot become a country of vigilantes. We will go off the rails so quickly. Can't do it. Can't do it. We're not talking about the what is that? I don't know what that is, baby doll. What is the typo there? Poger. I want to read your comments. I love this conversation. It's a great conversation. And I respect everybody's opinion. Yeah, but the concept's the same, baby doll. Back in the Old West, they took the law into their own hands because at some point, some vigilante's going to get it wrong. Or a bunch of vigilantes are going to get it wrong. Look, I'm as skeptical about the system as anybody else. You guys know that. You know, while I think that we have the best criminal justice system on the planet, it is incredibly flawed. I'm with you. I think that CPS, or we call it DCFS here in Illinois, I think it is a broken system. I'm with you on all those things. I really, really am. The government does get it wrong all the time. I'm with you there. Mandy nailed it. Great system, terrible players. It's what it boils down to. It's human error. That's what we're dealing with. We're dealing with human error and money. Those two things are what have our system broken. I don't know. I mean, he's a compelling person. It's compelling. I mean, he is convinced some that he should walk on this, but just understand, the jury is mandated to follow the law. He has been denied the opportunity of presenting the affirmative defense of others, meaning that he has no defense of this, short of him saying that it was self-defense, that she was going to kill him, or he reasonably thought that she was going to kill him. It's the only justification for it. As far as I know, and let me know in the chat if I'm wrong, that has not been raised here, which means that the only way he walks on this is by jury nullification, which the defense cannot argue, which means that we need a jury filled with baby dolls and Melanie Parkers, because you guys think that he deserves to walk on this. And while there is a strong argument that what he did, assuming that everything that's being said about the abuse of this child is true, there's something noble about that conceptually. But you have to look at the long game on this. You just have to. You cannot look at this in a vacuum. Can't do it. Can't do it.
And I had to do this in order to save Aida. So I don't remember how many times I struck her. I just remember that when it finished, we were on the ground, and I stopped striking her when she stopped struggling. And at this point, I stood up, and I was still freaking out, and I was in kind of a daze. And I was just trying to pull myself together and figure out what I needed to do to leave the house. And again, I wanted to make sure that I didn't leave anything behind that would connect me to it, because then I believe John would be connected to it, and it would only further put Aida in danger, because I didn't know if Christina Parcell was the only person involved in what was happening to Aida. And she wasn't. So I quickly looked around to make sure I hadn't left a mask or a glove.
Tina, I want to answer the question. Let me know what that what does the CSAM acronym mean?
And I started to pick up the rose petals and realized that I just didn't have time to do that. Again, I was concerned that a neighbor might have heard the commotion and that a neighbor might come by to investigate, and I didn't want that. So I drew the blinds and I moved her body away from the door, which had windows, because I didn't want someone to come to the door and see her. And I put my things back in the backpack, and I looked in a mirror before I left to make sure everything was in order, and I saw that she had scratched my face in the struggle. And of course, I realized that this could leave DNA. So I used the paint thinner to try to clean her hands. And then I changed my mask and I took off my outer shirt because there was blood on it. And I put it in the backpack. And at this point, I was really worried that someone, that Lutina might come back to the house, or Brad Post might come to the house, or a neighbor might come over. So I was trying to leave the house as quickly as possible. And before I left, when I realized that I had probably left my DNA there, despite my effort not to, I prayed again and just said that I believe that what I've done is the right thing, and I believe that I did it for the right reason. But if it's your will that I be connected to this, then I will turn myself in and I will own up to what I've done, and I'll take responsibility for it because I believed that it was the right thing. And then I left. I exited out through the door and I got back on my bike and I pedaled my bike back to the truck and I drove back to the mountain house. And I was still completely freaking out and it felt entirely surreal. But there was a big difference in how I felt, in that as soon as I left the house, I felt the most enormous wave of relief wash over me, because I knew from that moment on, Aida would be safe. Aida would be safe from the sexual abuse that her mother was perpetrating on her. And there is proof to that the state is hiding from you.
Your Honor, it's something to be quiet. Okay, can you stop talking? The jury. Please stop.
So I'm assuming that's what you were talking about. Like I saw that clip yesterday. That clip is what drew me in. That clip is what drew me in. Let me see. I am. So I see they have Stand Your Ground in Carolina, South Carolina. Let me see. I'm trying to pull this up here. All right, so all right, this is interesting. I'll pull this up real quick. Let me pull this over to my second screen here. See, this is why I love trials. And this is why I love our chat. And this is why we're not an echo chamber. This is open dialogue here. I love open dialogue. I love when people can debate over issues civilly. It's amazing. It's amazing. Civil discourse is everything. It's what makes our country so great. Truly. All right, let me see. So what am I doing right now? Oh man, like what a tricky closing. It's a really, really tricky I'm dying to see. Like I wouldn't even pretend to guess what I do here on the closing, knowing that you can't argue nullification. I mean, so he was barred from using defense of others and self-defense. Can anybody confirm that in the chat for me? So I'm going to pull up. It looks like it's got a pretty decent Let me pull this up here. I want to check this out. See what this says. Okay, so South Carolina, Chapter 8, let me blow this up for y'all. Okay, so under the law of self-defense, the defense may take another's life in defense of others. The right to intervene to protect another person is subject to the same rights and limitations as the right of self-defense. The defendant may take the life of a person who assaults a friend, relative, or bystander if that friend, relative, or bystander would have the right of self-defense. To show that the person being defended had the right of self-defense, it must first be shown that the person begin defended. What must now with the typo, the apparent typo? I'm not so sure about this website here. To show that the person being defended has the right of self-defense, it must first be shown that the person being defended and the defendant were both without fault in bringing on the difficulty. If the conduct of the person defended or the defendant was the type which was reasonably calculated to and did provoke a deadly assault, the person would be at fault in bringing on the difficulty and would not have the right of self-defense. So essentially what they're saying there, he picked the fight. So he picked the fight. Okay. It's like that old thing, you know, guys are more prone to fist fights than women are. At least it used to be that way. And, you know, it was always like if I was ever in that situation, you know, in the rare occasions that I would get into fights when I was in high school, that it was always for the defense of the honor of a woman, always, every fight that I ever got into. But I would always tell that person, like, hit me first, you know, so that I could make that argument. Well, they started it, and I have the right to defend myself. So that's that concept there. So if the conduct of the person defended or the defendant was the type which was reasonably calculated to and did provoke a deadly assault, the person would be at fault in bringing on the difficulty and would not have the right of self-defense. Therefore, the defendant would not have the right to use deadly force in defending that person. The defense of another person is excusable if the defendant had reasonable grounds to believe, and in good faith did believe, that the person being defended was in imminent danger of death or serious bodily harm from the victim. Man, I mean, and that's where this case lies, right? I mean, everything that I'm seeing in the chat, that's what we're talking about right here, right? I mean, do you guys know when this was heard? When was this argued? Was this at the beginning of trial, a motion in limine? I'd actually like to go watch it. I'd like to see what the argument was. So in deciding whether the person defended actually was, or the defendant actually believed the person was in imminent danger of death or serious bodily injury, you should consider all the facts and circumstances surrounding the crime, including the physical condition and characteristics of the parties. Wow. It says the defendant does not have to show that the person the defendant defended was actually in danger. It is enough that the defendant believed the person was in imminent danger. The defendant has the right to act on appearances, even though the defendant's beliefs may have been mistaken. The defendant must show that under the circumstances as they appeared to the defendant believed the person defended was in danger, and that a reasonably prudent person of ordinary firmness and courage would have the same belief under the same circumstances. So this is that language, as you can see, it is for you, the jury, is directly from the jury instructions. Yeah, let me see. Tracy sent me the stuff that's going on with Mello, who's the father. Let's see. Trace, did you email it or did you just text it? Let me check. Okay. Defense. Okay, wait. Okay. All right, so let's see. She sent a motion for limitation scope of cross-examination of Bradley Post. Who's Bradley Post, y'all? Why crickets? Why crickets? Bradley Post is Christine's boyfriend. Okay, all right. Let me see. All right, so I've got that motion and I've got another motion that Tracy sent. Okay. Response to state's motion to prevent the defendant from defending himself in the case. Okay. Wow. It's long. It's 46 pages. It's 46 pages. All right. So show me in the chat. I'd actually like to read that. I don't know if I'm up for reading 46 pages right now. Can you guys tell me, was this argument made recently, like where I can find it so we can watch the argument? Can you guys tell me that? Right. I have a feeling that Ginger's correct. I think that that's what the judge is going to hang his hat on, that imminent danger did not exist in this particular situation. Yeah. All right. Let's see. Yeah, the crickets always get my attention. All right. So the filing was 2 days ago, but there was no argument live streamed. Interesting. It was not streamed at all. Okay. Did the judge issue a ruling from the bench though that we heard that was streamed? Right. I think that's a valid argument, baby doll. How is not imminent? I mean, if it's a constant state of abuse, I think that the danger is always imminent. I mean, that would be the argument I'd be making if I were the defense attorney. Certainly. You know. All right. I'm not going to read the whole damn thing, but I'm going to pull it up. I'm going to keep checking in the chat. If you guys find where this was argued, also it was back in chambers. Damn. I hate that. Like if they've sent the jury back to the deliberation room, like why aren't they having the argument on the record? Like out for the public to see. It's that whole transparency thing that we're always bitching about over here. We need transparency. All right, let me see here. I want to pull this thing up. Take a peek at it. We shall take a peek. See what the defense is at least arguing. It's got to be illuminating. It's very long. It's very long. All right. And thank you for this, per usual, Tracy. I appreciate it. So this is the response to the state's motion to prevent the defendant from defending himself in the case. Okay. In America, defendants in criminal cases have the right to defend themselves, and so does Zach. Oh. The evidence will show that AM, and then we get a footnote, investigator Bevel used AM to refer to this child in the arrest warrants he obtained for Bradley Post. So was Bradley Post initially arrested for this? Was he initially arrested for this? Ginger snaps. Easy for you to say. It's 46 pages. I mean, you guys know I'm up to the challenge, but all right. So the evidence will show that AM was sexually abused by her own mother, Christina Parcell, and Bradley Post, Parcell's fiance, over many years. Oh, so he was involved. Was he charged with criminal sexual assault of a minor? Wow. Wow. Oh my God. This thing is sordid. This is sordid. The sexual abuse placed AM in imminent fear of sustaining serious bodily injury. One, John Mello, AM's father, reported to the Greenville County Sheriff's Office, particularly investigator Dan Bevel, at the end of 2017, beginning of 2018, his concerns that Parcell and or Post were abusing AM, and Bevel failed to act. Two, that AM's guardian ad litem, Vanessa Cormilo, had concerns about Post, but unfortunately was unable to uncover the essay until after Parcell died. A few weeks before October 13th of 2021, Zach submitted an affidavit in the family court proceeding where he shared he had concerns about AM's well-being while she was with Parcell, but nothing was done. And 4 days before October 13th of 2021, Zach reported to the South Carolina Department of Social Services, DSS, concerns that he had about AM being abused, and DSS did nothing. Wow. With AM's father stranded in Italy and subject to arrest on a pending warrant if he returned, a charge which was later dismissed at trial, the GCSO failing to act on child abuse allegations about which they were made aware years earlier with the guardian ad litem unfortunately being able to uncover the abuse, and with DSS failing to act after Zach reported abuse. Zach knew he was the only one who could save AM from continuing to be SA'd by her own mother, Parcell, and her boyfriend, Post. He acted to save AM, and he did save AM. Wow. At no time has Zach ever denied killing Parcell in the more than 3 years that this case has been pending. At no time in the last 3, God damn it. Ugh, I whiffed not covering this thing. This thing is like right up my alley. Y'all know how I love like self-defense, defense of other cases. Like man, dang. I whiffed, y'all. I definitely should have been covering this trial. Okay, so at no time in the last 3 years have defense counsel ever represented to the court or the public that Zach did not do it. Instead, in their pleadings and their representations to the court in hearings, defense counsel have repeatedly, consistently, passionately, and truthfully stated to the court that Zach is not guilty. The following explains in detail what Zach did and why, and the reasons why child pornography as evidence of SA is admissible and is extremely valuable. Footnote. See statements of Assistant Solicitor Jake Holfirth made to the court during the trial. And highly probative. 3, see statements this court made during the trial. Why Zach saved AM from the serious bodily injury at the hands of her mother, Post, and why Zach is not guilty. Facts. John Mello fancies himself as a music industry personality, musician, and music producer. Christina Parcell was a prostitute who advertised on the internet and who sold drugs. 4, defense counsel will seek to introduce an affidavit prepared by Alex Fields, a firefighter in Greenville County, who told members of the GCSO that Parcell offered to have sex with him for money, and when he refused, she attempted to sell him drugs. Wow. In 2012, they had a child together, a daughter, AM. They never married, and Parcell did not seek custody of or even full visitation rights with AM. Mello had primary custody of AM for most of her first 11 years. However, Parcell had some visitation rights, and AM would often spend the night with Parcell during her periods of visitation. During these custody battles, Parcell developed a romantic relationship with a man named Brad Post, who was old enough to be Parcell's father and who was, or at least perceived to be, very wealthy. Parcell and Post ultimately got engaged. Mello's also substantially older, right? I thought that I read that he was 65. Is that true? poor kid. This poor child. Oh, this poor child. That's who I feel terrible for in this case. AM. Okay, so Parcell and Post ultimately got engaged. Post and Parcell's relationship generally or greatly concerned Mello. Parcell's prior life as a prostitute and drug distributor, coupled with Post's wealth and creepiness, prompted Mello to wonder if AM was safe when she was with Parcell and Post. She was not. Post and Parcell essayed and victimized AM and another young girl, and Mello reports it. Wow. Beginning in 2017 or 2018, when AM was merely 6 or 7 years old, and continuing through 2021, Post and Parcell began to essay and victimize AM. They took hundreds, if not thousands, of nude and explicit photographs of her, some alone and some with Parcell also in the nude, along with other explicit and nude photos and or videos of AM's friend. Wow, what? So footnote 6, when investigator Bevel finally discovered evidence of the SA more than 3 years after Mello made his allegations due to the good police work of others, he listed the period in which Parcell and Post were abusing AM as January 1 of 2018 through October 19 of 2021, 6 days after Parcell's death. The state produced sanitized images of CP in its discovery productions. As this court will see, the extent of the harm Parcell and Post caused AM and her friend is absolutely critical to Hughes' defense, predicated on the doctrine of defense of others theory. Defense counsel will seek to introduce unsanitized versions of these photographs, videos, and or descriptions thereof during Zach's case in chief. The probative value of the harm caused to these children in these photographs and videos is so high, no amount of unfair prejudice can substantially outweigh the probative value of these photographs and videos. So in early 2017 or early 2018, Mello reported to the GCSO that Parcell and Post were abusing AM. Investigator Dan Bevel with the GCSO investigated the claims, and he and Mello began to clash during his investigation. Ultimately, Bevel determined that Mello's allegations of SA against Post and Parcell's were unfounded. In an email he wrote Mello on March 16th of 2018, Bevel stated in part, "I have complete faith that the judicial system will ultimately act in the best interest of your daughter. A child should never have to endure any abuse at the hands of any parent ever for any reason. I understand that you feel her mother is more than unfit. You have made that crystal clear. I am an investigator and a fairly decent one. As of today, the case is officially closed. I presented all of the evidence I uncovered to a judge, and a warrant was denied due to there being no probable cause. I'm going to ask you that you refrain from any further contact with me." Wow. So Mello was clearly losing it. Clearly losing it. You know, but I mean, if you're him, who wouldn't? You know, it's hard to put all of your faith into some dude with a badge that doesn't know you, that doesn't know your kid, that doesn't care. It's hard to do that. It's hard to just put your faith into law enforcement and say, "All right, I'm gonna leave it all to you." It's hard to sit back and bite your tongue when nothing seems to be happening. No matter, forget about this case. This is a general proposition I'm talking about. So Bevel wrongfully exonerated Parcell and Post. I don't know that he exonerated them. I mean, if he went in front of a judge and the judge said that there was not enough evidence to issue an arrest warrant, that's not considered an exoneration of them. However, I mean, if all of this evidence existed, did this evidence exist in 2018? All these videos and photographs? I mean, I can't imagine that this investigator got all of this stuff in his hands and brought it in front of a judge. He couldn't have. No judge would allow for that, right? I would hope. Like, he couldn't have produced that in front of a judge with his probable cause and having the judge deny to issue the warrant. So Bevel wrongfully exonerated Parcell and Post, and in doing so condemned AM to several more years of hellish SA at the hands of her own mother. All right, so this part I'm gonna like. So this is Zach. This is his life. He's born in Cali. Family moved to a small farm in Virginia. His parents, who were devout Christians, became interested in faith-based movement to adopt orphan children from Russia. They adopted 5, the oldest being a 10-year-old named Grace. Dave and Mindy traveled to Russia to receive these children and brought them back to their home in Virginia. Zach's parents had no idea that the Russian children they adopted had been severely mistreated, and they came to the Hughes family with tremendous psychological and emotional damage, especially Grace. In short order, the Hughes family learned that Grace was a sociopath, often lying, stealing, and displaying an utter lack of empathy toward her family members, both blood and adopted. Zach witnessed Grace lie effortlessly to his parents when they clearly caught her stealing or hurting someone else. He was amazed by how effortlessly she was able to lie at a moment's notice, and how she seemed to have no remorse. Let me see, I want to get the dates on this. So he's born in 92. So 2002, he's 10. So he's 13. So he's a few years older than Grace. Like, all this context helps. So on one occasion, Zach found a notebook Grace used. In it, Grace wrote in detail her plan to kill Zach's parents. Ultimately, Dave and Mindy contacted Virginia's counterpart to South Carolina's Department of Social Services for help. Grace fabricated a story of abuse, which was interviewed by VADS personnel, and amazingly, VADS launched an investigation into David and Mindy. After a costly and protracted investigation that traumatized David, Mindy, Eli, and Zach, VADS ceased its investigation and dismissed its allegations against David and Mindy as unfounded. So let me ask you this. I'm trying to pick. How do you know he lied about Grace, Eileen? Were you there? I mean, like, how do we know that he's lying about it? Like, I'm big on that. I'm big on people, like, saying things definitively when they weren't there. It's kind of like my whole concept with the state and or the defense in any criminal case. I mean, we have to argue it as if it's fact. The state has to. They can't come in saying maybe this is what happened. They have to argue it as if it's fact, but it's not. It's their theory. They're just arguing that it's a fact. It's a different thing. Arguing that something's a fact and it being a fact are not the same thing. They can be the same thing, but at the forefront, they're not the same thing until and unless you can prove it beyond a reasonable doubt. So Zach and his family moved to upstate South Carolina when he was a teenager, as a young boy. Okay, good at music. He's gifted, gets recognition, gets admission into one of the most prestigious performing art institutions in the world. So he goes to Juilliard. Only 7.2 applicants, all highly talented, were accepted. So Zach's at Juilliard. He evolves as a musician, plays international music festivals. He graduates from Juilliard, pursues a professional career in piano performance upon graduation. He was the principal pianist for Knoxville Symphony for a year, although he loves music and was grateful to have a career in music. The values David and Mindy instilled in him, especially for service to others, called Zach to leave the music world. And in 2018, he volunteered serve in the United States Marine Corps. So he joins the Marines. Okay, so his recruiter says you should apply for officer candidate school. He does. He's accepted. He got a perfect score is 300 on the exam. Or this was a physical exam. He got a 294. Unfortunately, 3 weeks into OCS, he suffered stress fractures in both. Say that 5 times quick. It's tough. Stress fractures in both of his legs, and he had to withdraw. At the time of his injury, Zach's superiors told him that he was in the top 3% of his OCS class, which was comprised of approximately 400 candidates. He encouraged him to come back, goes back to South Carolina. So then he meets Jeanette Wynn. So they develop a friendly relationship. So this is the thing where he wants to perform all of Beethoven's sonatas. The Winns and their church immediately supported the idea, and Zach knew he would not return to the Marine Corps. Sorry. COVID hits. Zach meets Mello. So he needed to make a little money, so he starts busking down in the streets of Greenville. And one day while he's performing, Mello and his daughter walk up to him. Mello told Zach that AM loved Claire DeLune. Is that DeLune or DeLune? And requested that Zach play it for her. He happily obliged, and Mello and Zach developed a friendship. Okay, so early October 20, Mello and Zach celebrate Zach's birthday. Conversation was jovial and lighthearted until the end of the evening. And that's when Mello starts getting into it. So Mello told Zach that he would be moving to Italy with AM when she returned. Mello did just that in violation of the court order announced to Zach. So he took his kid to Italy. All right. It's never good. It's kidnapping. It's absolutely kidnapping. You know, like a vast majority of Amber Alerts that we see are one parent kidnapping the other. Or one of the other parents kidnapping the child, rather. Zach was relieved when Mello and AM moved to Italy. Mello was interesting and good conversationalist, but he could be loud. And he was glad that Mello and AM were pursuing a better life. Communications between Zach and Mello slowed and became sporadic as they moved on with their lives. Okay, so Zach really wants to follow through with his dream of performing all the sonatas. He starts doing it. He's working at restaurants. In April of 21, Mello's communications with Zach increased markedly. Parcell had come to Italy, and she took AM from Mello back to Greenville. So that is not considered kidnapping because there was a court order in place. And she was bringing her back to where the court has jurisdiction over the child. So Parcell bankrolled by Post traveled to Italy several times to retrieve AM and return her to Greenville so Post and Parcell could continue to victimize her. 11. In her 2016 DEP, which defense counsel will offer, not for its truth, because it's well settled, the evidence is not hearsay unless offered for the truth of the matter that it's asserting. Parcell told opposing counsel that Post had ended their relationship the day before the deposition because he did not want drama with Mello. Now Post was willing to stay the course, likely because he knew Mello had an active warrant in Greenville County, which would be served on him if he returned to the United States, which effectively stranded Mello in Italy. Parcell also was now willing to stay the course, even though she had abandoned any attempt to gain custody of AM in 3 prior family court cases. All right, so ultimately, Parcell hired a lawyer in Italy and was able to convince an Italian judge that AM should be returned to Greenville. Also, she went through the court systems. and to her mother. According to Vanessa Cormilo, the GAL in the family case, Parcell and Post brought against Mello when he and AM left for Italy. Post proposed marriage to Parcell almost immediately thereafter. She and AM disembarked from the plane. Cormilo thought Post had a creep factor, especially because he refused to accept her invitation to meet with her. Red flag. Shortly after the return to Greenville, Parcell and AM, along with Parcell's sister, Lutina, moved to 122 Canebank Drive in Greenville. Post, quote, came to the house every day, 12. On cross-examination, this is the footnote, Lutina Parcell provided defense counsel with a combative and inconsistent answer when asked if she told police that Post came to the house every day. On cross-examination, the investigator, Jared Sparkman, when reminded that Lutina Parcell in her recorded interview said that Post came to the house every day, acknowledged that the recorded interview accurately conveyed statements Lutina Parcell had given. So I saw somebody sent something, or I saw it on Twitter, that there was a post, and I'm assuming it's the same sister who was railing against Mello in court yesterday, I think when he was arraigned. I'm assuming it's the same sister. Man, these family cases are so jacked up. All right, so there's another footnote. Lutina Parcell equivocated on cross when asked if AM had her own room and or whether her sister slept in the same room and or bed as AM. Cross-examination, investigator Sparkman, defense counsel, elicited from him that the recorded interview of Lutina Parcell, in which she said that Christina Parcell and AM shared a room and or slept in the same bed, accurately preserved her statements. So Zach begins to learn about Parcell and Post from Mello in April of 21. So it says Mello shared with Zach an email from a common friend he and Post had, wherein the friend told Mello that Post and Parcell were trying to recruit bikers to kill Mello. Wow. The information Mello told Zach about Parcell was even more disturbing. According to Mello, Parcell was a prostitute, and he provided Zach with proof in the form of online ads Parcell had posted years earlier, offering to engage in sexually explicit conduct for money. Mello was no angel, and Zach knew it. Zach did not accept at face value information Mello provided to him. However, the more he got to know Mello and heard and learned about Parcell and Post, the more Zach believed AM was most safe with Mello. Mello even told Zach at one point, AM is the only good thing in my life. I love her so. So footnote 14 says, Shannon McHale with GCSO seized in November of 21 from Post locker at Outman's some devices that contained CP. The state 15 state introduced evidence of these ads in their case in chief. So online sex ads were not the only proof that Mello had that Parcell and Post posed a danger to AM. Mello gave Zach a transcript of the Parcell dep from the family court case with Mello. In the dep, Parcell asserted her Fifth Amendment right when asked about being a prostitute and drug abuse. Mello also provided Zach with other graphic photographs of Parcell engaged in sex acts, as well as evidence that Parcell had an online alter ego, Carolyn Warren, that she used to entice men to have sex with her for money. Okay, now we get to the firefighter Fields affidavit, who she propositioned and then tried to sell him drugs. Zach had additional proof that AM was being sexually aided. Beside just Mello's statements, Parcell's deposition, Parcell's online sex advertisements and graphic photos, and Alex Fields' affidavit. Zach knew Parcell, even if he had never met her. All right, so we heard this testimony. I'm not going to read this. This is the entire, that she's Grace. She's the equivalent of Grace. Zach goes to Italy. Mello had online calls with AM. Zach was shocked. AM had gained what looked to be 20 pounds since he had last seen her. She was listless. She lacked any enthusiasm for anything. I could see the spark dying in her eyes. Then Zach tries to save AM. So this is where he does the reporting. sends the mailings to the law enforcement, the GAL, the family court, asking for a full investigation. He hoped they would act. He was wrong. They did not act. So he submits an affidavit to the GAL in September of 21. So he says, wow. Zach knew he was AM's only chance of survival. Quote, I thought I had to act to save the child's life. I told myself I can't go on with my great life and leave her to drown. Zach went about saving AM, both on her own. Wait, this thing seems a little oofy. Oh, we're missing page 16. I don't know what it is. 15's there, 16. He gone. All right, so on October 19 of 2021, Post met with investigator Jared Sparkman for a follow-up recorded interview in connection with Parcel's death investigation. Sparkman seized Post's cell phone and searched it pursuant to warrant. During the search, discovered numerous images of child P involving Parcell and Sparkman, and contacted Bevel to investigate this new criminal activity he had uncovered. Bevel immediately obtained a warrant for Post, and Bevel now knew that AM had been the victim of SA, but did not know the extent of the SA that AM was subject to and who from. He knew AM was in danger and had to move quickly. So after obtaining the warrant, Bevel deployed the Facet team to arrest Post. That stands for the Fugitive Apprehension Specialized Investigative Team. And its purpose is to track down subjects wanted for recently committed serious violent crimes. So Post is arrested at his house on the same day that the CP is discovered, October 19th of 2021. So other deputies, including Bevel, later that day executed a warrant at Post's house and found multiple electronic devices, at least one of which contained more CP involving AM. Man. Police also observed a guest bedroom with a pink alarm clock, a dollhouse, and girls' toys. Post testified that he has no daughters or granddaughters. So there you go. Clearly, Bevel knew that the danger to AM had not subsided, even though Post was in custody and Parcell was deceased. He sent a deputy to wake up AM in the middle of the night and remove her from her home and her aunt. So she was staying with Lutina, I'm assuming. He took AM into emergency protective custody. So is that who she was living with? Lutina? Y'all know? Okay, so the next day on the 20th, Bevel continued to work to eliminate the danger to AM. I mean, the reason that he's going through this is to establish that it was imminent. Not only was it imminent at the time of the death of Dean Parcell, that it was so imminent that this investigator thought it was still going on after Parcell had been killed. I mean, that's why they're at that. Like, if you're wondering why this is in there after the fact, that's why they're trying to make the imminent argument here. He attended and presumably testified before a family court hearing wherein the family court ordered that AM remain in EPC. In doing so, the family court presumably found that there was probable cause to believe that by reason of abuse or neglect, the AM's life, health, or that AM's life, health, or physical safety was in substantial and imminent danger. There you go. If she was not taken into emergency protective custody, and there was not time to apply for a court order. Okay, so 6 days after Parcell died and the day after Post was arrested, The harm to AM was so severe as evidenced by the images and videos law enforcement seized from post devices that the family court found that her life, health, and physical safety was still in a substantial and imminent danger. So footnote 20, defense counsel has sought to obtain the pleadings and transcripts for this EPC hearing, but these records are sealed in the family court. Bevel, although years too late, did more to try to protect AM on the 20th, 2021. He obtained more warrants for post based on the images of CP found on the devices. So we got various warrants here. AM was not the only child Bevel sought to protect on October 20th, 2021. Bevel saw images of AM's friend in post devices and he made contact with her parents to alert them of her victimization. Bevel continued his investigation, finds even more disturbing images of CP involving AM. Ugh, jeez. This is super triggering. I should have given, like, if I would have known it was going to be all this, like, trigger alert, super triggering. Sorry, I apologize for not giving a trigger alert. This is awful. This is this kid. Oh my God. I mean, the abuse is substantiated. What an indictment on the system, though. What an indictment on the system. So, I mean, I'm not even reading this. You can see this, the underlined here thing. Both Parcell and Post were active participants in the act. Finally, the offense contained in this warrant is a violent crime and requires mandatory SO registry under SC code annotated. Investigator Bevel, a member of the prosecution team, both in his reports and in sworn testimony, affirmed that Parcell and Post repeatedly perpetrated violent crimes and or crimes involving SA on AM. Parcell's own daughter from at least January 1, 2018, until October 19th of 2021, 6 days after Parcell's death. More disturbing images. Oh, thank God. Thank God they blacked these out. Okay. Okay, so then the trial begins. All right. So on Monday, February 10th, 2025, the court conducted an in-camera hearing of Brad Post's testimony. The court justifiably was concerned that Mr. Post would assert his Fifth Amendment right to remain silent to questions on cross. During cross-examination, defense counsel asked Post, quote, "Isn't it true that you worked with Ms. Parcell to create and distribute CP?" End quote. Rather than asserting his right to remain silent, Post testified, no, of course not. I mean, like, I feel now that I have the facts that substantiate that what Zach was saying on the stand about the abuse was true. I feel very confident that this was actually happening, that this poor child was being abused. However, it doesn't change my position. We cannot become a vigilante society. If anything, baby doll, where I would make the argument on behalf of this guy would be in sentencing, that he should get a severely reduced sentence due to the underlying facts. You know, I mean, it's like I, I've I've never taken someone's life. I can't imagine doing that. Like it would have to be like a real heat of the moment type thing, like where like like instincts took over. Like this wasn't that. This was a planned out thing. And I get what he's saying. I do. I get it. I get it. The system miserably failed this poor child. I mean, they might not. I find it hard to believe that they won't be able to bring it up at the sentencing hearing, Gwennon. I mean, they can't bring it up here. I mean, like, I wish we could see the judge's rationale. It has to be that he didn't find it that it was imminent. I disagree with that assessment. I do. Like, he's just not the guy to be doing it. You know, so here's an argument to consider. But for Zach doing this, does this evidence ever get uncovered? And I think the answer is probably no, based on how the system was failing. This is a horrible case. Oh man, that poor kid. Oh, see, if y'all know me, if you follow my channel, and I've told you guys that I like when I got out of college, I'm a sociology major, that I applied to DCFS. I took the state exam 2 times, scored 100 because I wanted to help kids. If I was that guy, if I was a child protective service investigator, you bet your ass this day does not happen. I promise you that. I promise you that. This kid was failed in the worst way possible. Yeah, I saw Sleuthie. It said that one of her friends was also a victim. Wait, I'm not arguing it. I'm posing a ponderable. Are you talking about, Ginger, are you talking about the concept of whether or not this evidence ever would have been? I mean, it's a question. It's not an argument. Do you guys think? I mean, it seems to me that the only reason that this evidence was ever uncovered was as a result of the homicide. You know? This, like life, is not black and white. This case, like life, is not. Like I say it all the time. We do not live in a black and white world. We live in the grays, firmly in the grays. Firmly in the grays. I mean, once and here's the thing, for those of you out there that believe that he's justified in his actions, which is absolutely your prerogative. Like, I think that the better argument for those that are making that argument that he was justified is that the abuse was imminent, that it was continuing, that had he not done what he did in that moment, that this horrible, unthinkable abuse that she was committing to her own child would have continued. It's a valid argument. And what's going to happen is, if he's convicted, is that is going to be a very powerful argument at the appellate court level. Now, you know, it's like if we abandon the law, we are going to slip into absolute chaos in this country. I mean, I am hearing y'all that are on the side that this guy was justified. I mean, look, I would be lying to you if I did not secretly, when I hear about these cases where fathers have taken matters of their own hand, giving a fist pump. Be like, dude. That being said, they've still committed a crime. They still need to do some time, but it mitigates it. It mitigates it. That is mitigating. And any judge is going to feel that way. Any judge with a moral compass that cares about children. Trish, love you, Bob, but this is a very special case and I'm for jury nullification. It's bullshit that the jury wasn't allowed all the info. I mean, like, I hear you, Trish, and that's what I'm saying. That is going to be the prime, if he's convicted, that will absolutely be the primary thrust of the appeal. And I think, based on what I'm reading, and again, I take everything, despite what people say about me on, from the trolling crews, I take everything with a grain of salt in terms of allegations contained in either the state or the defense's motions. I mean, there's always truth. These clearly are fact in terms of the evidence that was found pursuant to the investigation after the fact. That's factual. In terms of, everything else, in terms of the attorney writing it, is, written for a fact. I mean, a lawyer's right for a fact. That's not to diminish the factual information in there, and it's like, but my point being is that if he's convicted, that will be the thrust. And I happen to believe, assuming that this is all correct, this has all been preserved for the record, and I'm talking about the appellate record, that this is potentially an absolute winning argument that will end up in a remand, that this thing comes back. Slow, are you like way in the beginning? The sun's moved at this point. I don't think I have anything going on here. I mean, do y'all feel what I'm saying? I hear both sides on this. I really do. I really do. And I love this conversation. I love it so much that I wish that we could all, like all 400 of us could be on a Zoom just to have the convo. It's an important conversation. It's a fundamental conversation. Really is. I feel so bad for this kid. This poor little girl. Do you guys want me to keep reading this shit? Or here's what I'm going to do. I think we're coming back in an hour, or I think they're going to be back in a half hour. I want to go eat. You guys know me. No one likes Hangry Bob. No one likes that. I think I'm going to leave the chat open, though. We've got a nice crowd in here. We've got an amazing conversation going. I'd feel remiss to, you know what? I'm gonna text Josh. I'm gonna text Josh and see if he's cool with me showing his vid, so you guys aren't just sitting there. I'm not sleeping, y'all. I'm texting.
Are you sure? Are you
Yes,
sure?
I'm sure. Yes, I'm sure. All right, I text Josh. Hopefully, if he's not like working. The docs I just emailed is a civil case. Oh. Tracy emailed me some more deets. Oh, the mellow stuff. Okay. Oh, so this is this from the family law case? I'm assuming, Trace. Oh yeah. Oh yeah. Oh man. There's a lot here. There's a lot here. Oh, the layers of the onion. The layers of the onion. So I think they're starting at 2 Eastern, correct? If they're starting at 2, it will be streamed around 2:30. Okay. All right. Let's see. Miss Smith, in the past, Bob has indicated the charges being dismissed due to police misconduct sends a clear message of prevention for future cases. Would jury nullification send a similar message? I mean, different concept, and I love that. Thank you for that comment, Miss Smith. The argument that I'm always trying to make in terms of when charges are dismissed because as a result of a suppression of evidence because the police violated somebody's constitutional rights, that argument is that we as defense attorneys protecting all of your rights have to file those motions, because if we don't, it's beyond a slippery slope. It just gives law enforcement, the government, unfettered access to us and our persons and our homes and our vehicles and our information. Like so we have to file those to let them know you cannot do that. It's illegal. It's unconstitutional. So that's why we file that. I mean, Miss Smith, like if you play that question out to the end, if jury nullification happens here, I mean, I like the question would become, does that send a clear message to the prosecutors? Because be very clear about who decided to bring this case forward. It's the prosecutor's office, not the cops. Cops don't decide whether or not cases are going to be charged. That's firmly in the hands of prosecuting attorneys. So the question should be, would a jury nullification in this case send a similar message to that prosecutor's office? Maybe. You know, this isn't too dissimilar. Obviously, a completely different fact pattern, but this is not that dissimilar from the concept of seeing these parents that are getting charged for their unhinged children that are going up and shooting schools up when they find that the parents knew or should have known that their child was in mental peril. And they ignored it. And not only they ignore it, they then supply them with a gun. And now they're being held accountable. It's not that different than that, because at one point in time, after God knows how many school shootings have taken place in this country, hundreds, thousands, I don't know, like it's unthinkable. Somebody in Michigan finally had the balls to charge a parent. And I'm going to say warned you, I'm going to say predicted accurately that was going to become the norm. Once they got the convictions on the Crumleys, which were manslaughter, that was going to be the norm, that prosecutors all over this country, that when these things happen, upon further investigation, if they are able to determine that parents knew or should have known what was going on with their child and simply ignored it to the horrible detriment of other children losing their lives, you're on the hook, and you should be. So different fact pattern completely. Similar argument in terms of when a prosecutor decides whether or not they want to make a case of something or they don't. I mean, the prosecutor in this case certainly was provided with this information. Certainly was provided with it. I mean, the question here becomes to me when Zacahry at the very end of his direct examination let spill that all of the abuse proof exists and that the prosecutor's hiding it. I'm assuming that there had to have been an oral motion for a mistrial by the state. Because, I mean, he got it in. He slipped it in. It's not the details that you may want, but that jury heard it. And you've heard me tell you a million times those admonishments about, oh, I want you, what you just heard, forget about you. Bullshit. Nobody's forgetting about anything in that jury box. Can't unring a bell. I say it all the time. Man. Man, oh man, oh man. What a case. All right, let me see if Josh answered. He hasn't answered. He might be working. I'm sure he wouldn't give a shit, but I always like to check with my friends before I use their content because it's the proper thing to do. Oh, and by the way, just a little reminder, if y'all don't know, Ian Runkle. I'm so excited. I love Ian. He's brilliant. He's hilarious. We're going to have a great time together. I first met Ian a couple of years ago. It was last year. Allie and I met Ian at CrimeCon. And we hit it off. And we've been talking offline about doing something. And like, I'm like, dude, because like, and Ian is an absolute, like, Ian has forgotten more about guns and ballistics, formerly known as ballistics. Tool markings is what they call it now. He's forgotten more than I've ever known. So like I've been telling Ian, like, we're not going to get into that tonight, but I'm going to have him back because like I've had somebody in Allie and I have both had somebody in our DMs relating to the Allen case that's provided us like a ton of information that they could prove that there's no way that they could have done the testing on that. It sounds like he's a metallurgist. So I want to bring Ian back for that, but I want to provide him all this information ahead of time so that he's armed to come back and talk about it with us. So that'll be great. But tonight, 7:00 Central Standard, I'm hoping Allie can join us. She's feeling like it. So I don't know. All right, let me think here. Let me look at my content and see if there's anything you guys can watch. So I think I'm going to keep the stream going. I want to keep the stream going, even though we got an hour. I should force you guys to. I can let you guys watch Cameron do ASAP Rocky's closing arguments, defense. She crushed it. She's great. I could put on Andy's interview for those of you who hadn't seen Andy Baldwin. We could throw on Whiplash Tuesday. Pretty good. That was a little Reed, ASAP, and Alan. Or you guys can just sit there and chat while there's nothing on here other than this. It's up to you. What do you guys think? What do you guys think? Let me know in the chat. So yeah, so Julie, the closing start in a half an hour. The problem is there's a delay. There's a delay. What do you got? Ask it, Lisa. Oh yeah, I'm definitely going to read through the Idaho docs. Well, I mean, if you like, so I'm assuming that you're talking about the judge's order, which is 39 pages long. Is that what you're talking about in terms of docs? Yes, I did not. I thank you for sending those to me last night. I started to read them. 100% going to be going through those. I can open them up, but it's just going to be the first page because I'm going to go eat. Know what I mean? I'm definitely going through that. See, and like whenever you see Marissa, are you talking about in this case? Is there a pro hoc guy on there? Are one of the lawyers pro hoc in this case? Oh, what? Did somebody pro hoc in for Koberger? Shit, I don't know. Let me see. Is that new news? Let me check. Does anybody know? I hadn't heard anything about somebody pro hawking in. Was it a while ago or is it recent? I haven't seen anything like that. But yeah, Lisa, 100%. I might do it as early as tomorrow. So the other thing that I was talking to the team about, I am going to start setting a set schedule. I think that that will really help the channel. I'm going to have set times for lives daily. Obviously, breaking news, that's different. If I'm jumping on because something's breaking, that's different. But tentatively, the way it's going to be set up is I am going to do lives on Monday and Wednesday at 5 Central Standard Time. Every Monday, like a set schedule. It's going to be the same thing, like clockwork. You guys are going to know, unless I'm like ill or traveling. It's like you'll be able to rely on it always happening. And then at 7 p.m. on Tuesdays and Thursdays. And then Fridays, I'm going to do an afternoon live. So that is going to be the set schedule. You know, when I'm having guests on. So just so you guys have a heads up, as to next week, because like I promised coming into the new year, I was going to get better about scheduling. I was promising my mods that I'm going to, for their own benefit and out of courtesy to them, because they're so incredibly gracious with their time, that I'm going to start giving them a heads up. I know I did, like, this was not an example of what I'm doing. This was decided about 10 minutes before I did it. So I'm going to have Lauren Conlon on Thursday. So that will be a 7 o'clock live. Lauren is going to walk us through Lively and Baldini, or whatever his name is. I don't know shit about that case. I know there's a lot of people interested in it, and Lauren knows it backwards and forward. So I'm going to have her come on, and because we've been wanting to do something for 6 months. Oh, Jacqueline, happy birthday. Happy birthday to you. Happy birthday to you. Happy birthday. I'm singing, man. You ever seen some? I'm like singing a beautiful rendition of Stevie Wonder, Happy Birthday to Jacqueline, and she's playing Hot Pocket. What's going on? Jacqueline, happy birthday. We love you over here. We love you, love you, love you so much. I hope you're having a wonderful day. I hope you're doing more than watching my stupid ass all day, too. So I hope you're getting out and celebrating you at some point. So yeah, Lauren's gonna be Thursday, 7. We've got Josh, not Josh Ritter, my very, very, very good friend. Josh Schiffer is going to come on, who, if you guys watch Core TV at all, you know that Josh, brilliant dude, hilarious dude. He's like a Runkle. He's like in a Georgia version of Runkle. He's down there, down south. Guy, I love him to death. Super smart guy. And I'm going to talk to Josh about whatever he wants to talk about. Josh is knee deep in all the shit like I am. You know, he covers everything. So I'm trying to get that pushed for Monday. I'm trying to set that up with Josh for Monday. That is not in stone. Lauren is in stone. I'm going to have Vinny Politan on next week. That'll be like Vinny does days. Vinny works at night. So that will be a day. Vinny doesn't work on Fridays. He's not available on Friday afternoon. So that will have to be an exception to the rule, an exception to the schedule. I'm going to get it firmed up with Vinny as to what day he's going to come on. Vinny's awesome. When you know, he's awesome on Court TV. He's even more awesome when he's able to let his freak flag fly, you know, here on the tubes. So that'll be great. So that's the tentative schedule for right now. I'm going to start having a lot of guests on, because I think you deserve it. And I got a lot of friends. In the business. So I think I should take advantage of that and have them over here. So wait, which trial? What you talking about? Oh yeah, if there's great trials, yes, we will definitely be having live trial coverage. I was just talking to Tracy and Mandy about that last night. Like my preference is not to have like month-long trials. It's a lot. Like a nice 5-6 day trial is tasty. It's tasty. So yes, there will definitely be trial coverage. Allie's very anti-trial coverage. She's like, we don't like for as much work as we're putting in, we're not making enough money on it. And I'm like, yeah, but I like doing it. It's a good way to spend the day. And I think it builds the channel. Like building the channel is the point, right? And I think that good coverage. All right, you're right. I'm gonna go eat. All right. So do you guys want me to throw something on while we're killing time, or do you just want me to throw you guys just want me to throw the window up? The courtroom. Yeah, I'll do that just in case. So you guys chat amongst yourselves. Okay, I'm gonna put this guy up. I'm gonna go get a little food. So I stay in a good mood. You can tell I'm in a good mood, right? It's always very evident when I'm in a good mood. You don't want me to shift into hangry man. Angry man, angry man. Jacqueline Ha, happy birthday. All right, I'll see you guys in a few. I won't be gone that long. Be nice to each other. Be kind.
Thank you
Always.
very much. Thank you very much. Thank you
Oh, I was doing my lockout impression.
very
Later.
much. Thank you very much. Thank you very much. Thank you very
Okay. Thank you again for your attentiveness. We are about to begin closing arguments. Stand.
Thank you, Your Honor. Please report. Good afternoon, ladies and gentlemen. This is the moment where myself and the defense have an opportunity to speak to you directly. It's called our closing statement, our closing arguments. All the evidence that you're going to hear in this case, you've already heard it. It's either sitting right here or it's through testimony that you've already heard. And so my goal here is to just talk a little bit about this case with you and sort of explain the state's perspective and how we have proven beyond a reasonable doubt that Zacahry Hughes did in fact commit the crimes that he's alleged to have committed. And I'm going to go through those crimes a little bit, and we'll talk a little bit about that. And then I'm going to go briefly through the evidence and explain my perspective on those things. I will give you a bit of a caveat that this is a little bit of a unique case in that you rarely have the defendant testifying and admitting to the entire crime during the trial. So in that respect, my closing argument may be a little different or maybe a little abnormal than our normal way we do things, but I'm going to do my best. I first want to thank you for your service. It's been a long 2 weeks. Y'all have been extremely attentive. You've paid attention. You've listened to the judge. And to be frankly, I couldn't ask for a better jury, and I appreciate your service. On behalf of my co-counsel, Mr. Jake Hoferth, Investigator Jared Sparkman, and Master Deputy Blake Wolf, we thank you for your service. Now, I told you in my opening statements that once you see and hear all the testimony in this trial, and I did not know that the defendant was going to testify, you're going to find that Zacahry Hughes, I don't know if you remember what I said, is a cold-blooded killer. And I submit that the state, and along with the testimony of Zacahry Hughes, we did in fact prove all of that beyond a reasonable doubt. Zacahry Hughes is a cold-blooded killer. Zacahry Hughes is an admitted cold-blooded killer. And keep in mind, he solved John Mello's problems. So the judge is going to instruct you on the law, and just as we just abide by, we're going to abide by his rulings, you must abide by his instructions. Remember, I told you he's the referee, calls balls and strikes, and he also tells us what the rules are, what the law is. Y'all took an oath way long ago than you can probably remember, back in last week on Monday, a week ago. And you said you would take an oath, you would adhere to his instructions, you would do your duty as jurors, and I have no doubt in my mind that you will absolutely do that. Now, before Zacahry Hughes admitted to the murder of Christina Parcell, state called approximately 32 witnesses. We submitted close to 200 exhibits. If you put all this on a hard drive, it's a little over 4 terabytes of information. And all of that taken together, it's a lot of evidence to digest. Now, with the admission of Zacahry Hughes to a lot of the state's case, the questions you were presented with at the beginning of the case really are answered. Regardless of what he may believe in his head, his actions are what matter in this courtroom. Actions speak louder than words. And boy, do we have a lot of cold, calculated, horrific actions in this case. Now, ladies and gentlemen, you must find the facts based on the evidence in this trial and solely based on the evidence presented at this trial inside this courtroom. And it's undisputed that Zacahry Hughes planned, he lay and waited, he broke into Christina Parcell's home with a .22 and a knife, some roses, She had just returned home from an interview, from her last interview with Vet Tech. Zacahry Hughes, a person she had never met. She had never met him. Beat her with a gun, brutally stabbed her 35 times, severing her jugular vein and her carotid artery. Now, as we go through the evidence and we look at some of the different things, I'm going to ask you to keep in mind of the charges that you're actually looking at. So the first charge I'm going to explain is the harassment charge. And there's two harassment. There's harassment and there's conspiracy to commit harassment. The only difference is that conspiracy requires two or more people joining and to commit the harassment. So harassment is just a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that serves no legitimate purpose and would cause a reasonable person in his position to suffer mental or emotional distress. That's related to all those photos and those documents that you saw mailed out. I think there's 7 envelopes full of photos and other documents. You heard testimony about what was in those. Some of them are in evidence. Some were just described because those were pictures of Christina Parcell without any clothes on. So we didn't introduce those so as not to embarrass her or her family. Burglary first. A person is guilty of burglary first if he enters a dwelling without consent and with the intent to commit a crime. And I remind you, the judge is going to tell you the law is, what it is. I'm just trying to give you an outline so you can keep that in mind as we're going through this evidence. And they enter without consent and are armed with a deadly weapon or cause physical injury. Well, those things all already appeared in this case. Zacahry Hughes went in under a ruse of roses, according to his own testimony. But he went in directly with the intent to commit harm, and he had weapons on him. And then you've got murder. You also have possession of the weapon during the commission of a violent crime. That is, if you used a weapon and you murder somebody, that is the possession of the weapon during that commission of a violent crime. But you have murder, which is the killing of any person with malice aforethought. Malice aforethought. And you're going to hear those words a lot in the judge's instructions. But malice is ill will towards another person, the intentional doing of a wrong act with the intent to inflict injury. And I think I said early on, ladies and gentlemen, it was a depraved heart, an angry heart with the intent to harm somebody. And there's also express malice, meaning it's expressed. It's right there in front of you. And it's shown when there are words of hatred or when someone prepares to do the act. They prepare to go in there. It's called premeditation. Is what you'll hear the judge charge you. Premeditation is preparing to go and harm somebody, like lying in wait, like buying weapons beforehand, by concealing your identity, going in there. Those kinds of things are premeditation, things that you do in preparation of the violent act. And if you find those things, and you find the state proved those beyond a reasonable doubt, then you can find the defendant guilty. So, before we get in, let's start with a little background now. You know the players, you know everybody involved in here, you know the victim. You've heard a lot about the victim, Christina Parcell. You've heard a lot about John Mello. You've heard a lot about Zacahry Hughes. And you've heard a lot about Christina Parcell and John Mello's daughter. So the background, and we're talking the time frame from 2020, October 2020-ish, to October 13th, 2021. So we're roughly a time span of 1 year. And what happens throughout that year that leads up to the murder of Christina Parcell? Zacahry Hughes never talked to Christina Parcell. He didn't know Christina Parcell. He never met Christina Parcell. And everything he knew about Christina Parcell, even according to his own testimony, was told to him by John Mello or shown to him in certain evidence. John Mello was in a nasty custody battle with Christina Parcell. We all know that. He was on his 4th round of custody disputes with Christina Parcell. Keep in mind, and according to the guardian ad litem, the prior 3 were just as nasty, but they'd always been settled where John Mello would have significant custody of their daughter. But in April of 2021, that changed. The tide changed for John Mello because he took Aida out of the country in violation of that order, according to the Italian courts. And he took her to Italy. And Christina Parcell didn't even know about that until she saw a social media post where she realizes my daughter's out of the country, I can't see or talk to her, and she's with her father. Thus, the continuation of this nasty child custody dispute. And then from October to April, Aida was living in Italy with little or no contact with Christina. So what did Christina do? She did what any mother would do, is she tried to get the return of her daughter. So she went through this process, and it was explained by Christina's sister, Tina Parcell, as well as the guardian ad litem, Vanessa Cormelo. She filed under what's called the Hague Convention, and she asked to have her daughter returned to her. She actually flew to Italy twice to have these hearings in Italy. And she was successful. She won that particular battle in this myriad of battles of child custody that have been going on between these two individuals. And so in April of 2021, that really set off John Mello. He was unhappy. And we know the things, and we're going to talk about the things that he did starting that day through the WhatsApps, through the harassment letters, everything else, to solve that custody dispute problem. And that's where this case really, really began. That is when things turned not in favor of Christina Parcell. She lost her life as a result. So what is the relationship between Zacahry Hughes and John Mello? All right, so where did they all come into this mass of characters? Well, according to Zach, he met John on the streets of Greenville about August of 2020, and he was with Aida, and Zach played a very likable classical music piece that John Mello and Aida liked. And that's how they met. So they met that one time. That was one of the few times that Zacahry Hughes actually met Aida Mello. And he talked about, they went on about 4 or 5, maybe 6 occasions where they were hanging out. They got some tacos one night. They saw a museum. But Aida Mello didn't know Zacahry Hughes. She didn't know who he was. She's a 9-year-old little girl who heard him play a piano piece, who's a friend of her dad's. And that's all the time they ever spent together. That's it. In August until October, John Mello left for Italy. And with him went Aida. So Zacahry Hughes never spent any more time with Aida, what little time he did during that small time, ever, never again. Now, he may have seen her on a FaceTime while he's talking to her dad. Or he may have seen her or seen videos of that, which he testified to. But Zach acted on this stand as if he could see into her soul. He could see into her eyes. He knew how she was feeling. He could tell that she gained weight and why she gained weight at a certain particular time in her life, in her adolescent life. He is drawing those conclusions on a little bit of information and nothing but whatever John Mello is feeding him. So, what's their first thing? Aida's back with her mother. She, in May, begins living at Canebrake with her aunt, Tina Parcell, and that's where they're living there. John Mello's in Italy, and Zacahry Hughes and John Mello decide, well, you know what we're going to do? Let's embarrass Christina Parcell. Let's make her life look bad. Let's make her look like a prostitute. That'll help me get custody of her. That'll help me with the guardian ad litem. And so John Mello, according to Bevel, Detective Bevel, who testified, had photos, and according to the evidence right here, he had photos of Christina Parcell. And those photos were taken when she was much younger. And those photos are taken between 2 consensual adults engaging in what acts that 2 consensual adults can do. And that's it. And then he took those photos and he used them as a weapon. And he tried to make her look like a prostitute. Because that's what John Mello continually told Zach Hughes, according to his own testimony, Alex Field's affidavit. Let's make her look like a prostitute and let's send them around to a neighborhood. Well, they sent them to a neighborhood where Brad Post lived. They didn't even send them to Canebrake. And we know this because in these WhatsApps, they talk about it specifically. They talk about, may I present to you my daughter's mother, Christina, Caroline Warren, escort. And we know there's a bunch of attachments that we can't see because Zach Hughes deleted these on October 13th. And when we retrieve them from WhatsApp, they're deleted. So you have to see us, investigators department, manipulating these WhatsApps. And then they sent them that way. And then Zach Hughes receives them. He gets them. And he sees an email that was sent to him as well. This email is very important. And he prepares all these packages to Brad Post, to Mr. Bradley Post. These are all his P.O. box. Brad Post. Cigar bar, where Brad Post hangs out. Misspells Mr. Post one time in the WhatsApps. Misspells it here, P-O-A-S-T, which is why we know it. But Zach Hughes admitted it. But this email here purports to come from Mullen Investigations. Mullen Investigations at protonmail.com. And it's cut out. And you've got this photo of Christina Parcell, and you've got another photo of Christina Parcell back there, which is the same ones that are in here. But there's no URL with Bella Donjon right here. And this is the escort site, and it says Caroline Warren. She became a member, Caroline Warren, in 2009. Well, this is 2021. And apparently this Mullen Investigations on May 16th found these photos attached to this website, except the photos don't have anything attached to the website. It's just a square of an escort site of Caroline Warren. Well, I don't know who that is. I know this. I know Caroline Warren. I know Mullen Investigations, John Mello. Vanessa Carmelo testified to it. She received emails from Mullen Investigations, and she received lots of emails from people purporting to be John Mello. So Zach Hughes went to the trouble of preparing all these envelopes, manipulating all the items, the photos, the escort, and putting it together. And he wanted to make sure we knew it was her. And so we would add a cover letter. You can see the cover letter that he would do. He had to add a cover letter to make sure you knew exactly who that was, that it was Christina Parcell that was engaging in prostitution. And he sent them out to shame her, to make fun of her. There's WhatsApps in there saying, we're going to ruin her day. And Zach Hughes did it the same way he committed this murder. He used his bike, he avoided cameras, tried to find a location, and he didn't know that we could track his phone. And so we know he was in Greenville when he mailed those in June and July, and he was in Tennessee when the other two were mailed. So we know he did all that. But the big point of the harassment is not that that's bad to do somebody. It's really what Tina Parcell referred to as revenge porn. South Carolina does not have a statute for revenge porn. We have harassment. And that's exactly what that is. But he's really doing it, one, to make her look bad, to make her look like a prostitute. But he's also trying to do it to gain a strategic advantage in this custody battle. And it doesn't work. He even sends one to the guardian ad litem. What does the guardian ad litem do? She investigates everything. But Brad Post put a lot of work in. Zach Hughes put a lot of work into that. It's a lot of work finding all those envelopes. To somebody he doesn't even know, he's never met, never talked to. Now, John Mello, I would say he's pretty much a liar. He dated Christina back in 05 and 06 and had their daughter in 2012. And of course, this custody battle. And if you want to look about the character and who John Mello is, I refer you back to Vanessa Cormelow's testimony. She testified that John Mello would do horrific things in relation to this custody battle. To her, to a lawyer who's representing a little girl as a guardian ad litem who's practicing law for 26 years, he would accuse her of horrific things, according to her. He would accuse her of trafficking children in Spartanburg. He would post things on social media ridiculing her. And that's how John Mello operated. That's how he operated. He used deceit by using fake emails. He used threats to try to get what he wanted. Mullen investigation. He sent those to Vanessa Cormellow. He sent an email pertaining to be a lawyer named Sophia Carlucci, according to Vanessa Cormellow. And she knew it was John Mello writing it because she's read so many emails from him, they matched up. So he's trying to gain a strategic advantage. John Mello and Zacahry Hughes were trying to harm Christina because John Mello had a custody problem. And the only way to solve it was murder. So Zach visits John for 3 weeks in June in Italy. So he met him for 5 times between August and October of 2020. They're having lots of conversations on the WhatsApp, and he's in 3 weeks in June in Italy. And it was a pretty important moment when Zacahry Hughes said, John Mello offered me $5,000 to kill Christina Parcell. John Mello offered me $10,000 to kill Christina Parcell. Now, of course, Zach said he wouldn't take that money. He would just do it for free. Because killing Christina Parcell is the right thing to do. So I submit that's when the plot to murder Christina Parcell began. That's kind of when this evolved. And I think they started with the photos, which were in June and July, but that wasn't going to carry any weight with anything. Interesting that a struggling pianist turned down $10,000. Do it for free. Especially of a person he's never met on behalf of a little girl he barely knows. Now, much of what Zacahry Hughes said, I believe, on that stand was true. I think a lot of it was a bunch of self-serving, narcissistic junk. Zacahry Hughes is trying to portray himself on that stand as a hero instead of the cold-blooded killer that he is. Ladies and gentlemen, we judge the defendant by their actions, not by their excuses or their words. Actions speak much louder than any self-serving lies from a sadistic, pathological killer like Zacahry Hughes. He murdered Christina Parcell, mother to Aida, sister to Tina Parcell, and daughter to Erica and Tim Parcell. Now, I've talked a lot about Vanessa Cormellow because she's a key witness, because that is the dispute that we're having, the custody battle. And she's in charge of making recommendations about who should get custody. Her job is to investigate the custodians. She stated that she investigated every allegation which were at Christina, which was involved in prostitution and drugs. She stated she would investigate every allegation, hire private investigators, put trackers on cars, meet with potential custodians, have home visits, and talk with the child constantly. So she's doing everything that she can possibly do. She even had allegations like Alex Fields. There's an affidavit that the defense submitted on Alex Fields, where he says that he was propositioned by Christina Parcell for sex and offered to sell him drugs. And he put in an affidavit. This was after John Mello put on Craigslist, "You have any information about Christina Parcell that I know about? I'd like to know anything about." Who responds to a Craigslist ad about somebody and then sets an example of what they did at a bar? And for what purpose? Maybe it's true. Maybe it's not true. I have no idea. That's what Alex Fields says. Really doesn't matter. While the defense wants to impugn the integrity of Christina Parcell as a justification for committing murder, so be it. If doing bad things means anyone can break into my house and stab me 35 times without retribution, then two things will happen. There'll be a lot of people stabbed to death, and I'll be out of a job, because all we'll have is vigilante justice in our system. But again, these are allegations that John Mello is making. He's looking for any dirt on Christina Parcell. Again, these are all allegations. Well, let's come to October. Vanessa Cormelo was getting close to making her decision. Who's going to get custody? Her investigation revealed that before Christina's murder, she would write a favorable report for Christina Parcell and a bad one. That's what Vanessa Cormelo said. In addition, it was almost 6 months since Aida had come home, and that's important. 6 months. Someone can file to terminate the parental rights of another. We were about to be 6 months. Zacahry Hughes said October was the time that he felt it was the time to kill her. Just felt it in his heart and his mind. And he tried on the 12th, did it on the 13th. That is important because it was getting close. John Mello's getting a bad report, and things aren't going to go his way. So he's got a problem. Now, if Christina Parcell is no longer around, he's the last man standing. He's going to get custody. So Zach admittedly decides to murder Christina Parcell. That was his intent. He bought a gun and a knife about a month before. It was weighing on his soul. Custody dispute's not going well. And so he entered into a lot of planning going into this murder. A ton of planning. And the state presented all of this evidence to you before he testified. But we know that Zacahry Hughes on the 12th was up at the Mountain House because his phone showed that he was up there. And while up there, he had his truck. And we know he put his bike in the back of the truck. And we know he parked it somewhere. And we know that he decided to park somewhere near canebrake and ride his bike in there. And we didn't know, but we know that he knew the schedule of Christina Parcell that day because he said John Mello told him. So he gets in his truck, and I would submit he arrives around 7:42-ish to somewhere wherever he parked. We never learned exactly where he parked near canebrake, but we know he parked somewhere there, and he rode his bike. Because at 7:42, we know from his phone that he plugs it in and unlocks it. And that's the last activity on his phone at that time. So he parks, maybe he plans, he thinks, and he gets on his bike and he drives in. And we know he drives in because he passes Donna Gorman's house. And Donna Gorman was an early witness from the state. And she did an identification of Zacahry Hughes from that witness stand. State was not expecting that. We had never shown her a photo lineup. We'd shown her a photo of the bike, of Zach on the bike from the ring cameras. But she had never seen Zach in person. And so we just left it. Now, we did wait until about 3 years after the murder before Donna Gorman told us that information. That is true. Riley Stokes talked to her that day, and he didn't have a copy of it. Master Deputy Wolf talked to her on the 19th, and he didn't show her a copy of the person on the bike. And so there was so much chaos going on, so many officers moving in so many directions, trying to find the evidence to solve this murder. It was just overlooked. And so when we went and talked to her, this was her testimony. And that's what we presented to this jury. She was right. She was right. The DNA proved it. Zacahry Hughes proved it. So Donna Gorman sees him, and she says it's around 8:15-ish when he goes by. And then he goes to Christina Parcells' house. And my opinion is that he went and he hid under the bottom of the house. His testimony was different. He says different. He says that he got there and went straight in, dropped his bike, and went to the front door. We have a difference. Maybe he's telling the truth. Maybe I'm wrong. At the end of the day, it doesn't really matter. But I submit that he went and he waited. He had an hour to wait. Of course, he had an hour drive from the Mountain House all the way to Canebrake. And you know what he could have done? He could have turned around. He could have done anything he wanted. He could have gone to the QT. He could have changed his mind. Had many opportunities to do that. He was committed. And so he went and he lied and he waited. And he waited for a time because he knew her schedule and he knew her car. He knew her address. That's in evidence. And he went and he decided to walk in the front door with roses as a ruse, according to his testimony, with a gun and a knife and a backpack, paint thinner so he could clean up afterwards, and he kills her. So let's see the moments before Christina Parcells is murdered. Zacahry Hughes, dressed as he said he was, gray sweatshirt, backpack, black pants, walks directly into that house. I can't see if he's carrying flowers. I know he was. I know he had flowers on him. And he walks in and he surprises Christina Parcells. Points a gun at her and hits her in the head with the gun. And then he stabs, and he begins to stab, and he begins to slash, and he begins to slash, and he begins to stab, and stab.
This guy is not an effective orator. Like, he is, either he's awful at this or he ain't feeling it. I mean, I abhor victim blaming, but this woman was not good people's. I mean, you can tell he's not, he doesn't have the passion at all. I mean, in a jury nullification case, he's got to be hammering home that point that he made, which I've been making all morning about we can't turn into a vigilante society. It's a scary proposition for him because he's acknowledging that jury nullification is essentially the only way. I'm assuming he's going to argue that at the end, that they can't do it. They're not allowed, but we'll see.
Stab and slash. Now think of the force needed to stab someone in the chest, stab them in the back, all over the head. And finally, and through all the fighting,
J-Bo!
the stabbing, and the pushing, while Christina is fighting for her life, he finds the vulnerable spots, stabs her in the jugular and the carotid artery, causing her to bleed out. With blunt force trauma to the head, she has to be on the ground. Blood is everywhere, pulling around her dropped phone and the couch. But that's not enough. He drags her through her own blood to cover up the crime as he closes the curtains and locks the front door so he's not detected, as droplets of blood fall from his blood-soaked clothes. She remains laying on that floor in her own blood with nothing but her blood-soaked scrubs and her wedding band that Brad Post gave her. But his sadistic actions are not over. I submit, ladies and gentlemen, those rose petals had a dual purpose. He may have used them as a ruse to get in and get inside the house so he could surprise Christina and gain that strategic advantage to murder her. But he also sprinkled them around. He sprinkled them around the house, on her purse, around, as some sort of sadistic, artistic sign that he thought was necessary. Then he had to keep in line with the allegations: prostitution and drugs. Put a bag of cocaine under a couch,
Little
a chair,
blow, little the
right down
blow.
from her body.
The devil's dandruff.
Killing her wasn't enough. Shaming her was the goal too. This was not to save Aida. This was to help John Mello win his custody case.
Yeah, but you're talking out of both sides of your mouth. You just said it for a guy he barely knew. So now he's doing shit for a guy he barely knew. That's who it was for. This dude's closing. Needs work. Needs work. I could get up there right now with as few facts as I know about this case and blow this dude out of the water. Guarantee it. This guy's like walking right into a nullification.
He never told us about the drugs either. Never mentioned those.
Wait, how do we know that the drugs were planted? Do we know?
So then the cover up. So then after you effectuate the crime, you commit it, then you got to clean up. You got to cover up. So he first had to cover up the scene. He had to worry about that DNA under her fingers. That DNA is key to this case. He had to wipe her fingers down with that paint thinner. He did not want to get caught. Pre-planned, and then really good exit strategy, cover up. Then he went back to the mountain house. Of course, we know he's there.
Jay, I'm listening. What are you thinking? What you thinking, man? We all want to know. Inquiring minds want to know. I'm sorry to pause this riveting closing. Let me get right back to it. Tell us. Tell us.
Because his phone puts him there around 1:17. He connects to the Wynn Wi-Fi. The Wynns have a mountain house. He has access to it. Remember, it's real remote. I think Master Deputy Wool said it's so remote you could walk around naked. Nobody would see you. Perfect place to clean up a crime scene like that. Can you imagine how soaked in blood his clothes were? Can you imagine how soaked in blood his car was? Can you imagine how soaked in blood his bike was? And he did. And he admitted it. Burned his clothes, ditched the knife and the gun in some pond, cleaned up everything, and he went back to Tyndall about his daily life. And that's what he said. I've mentioned Zacahry Hughes' testimony a lot. And I'm sorry that you had the unfortunate privilege of hearing the specific testimony of the killing of Christina Parcell by a cold-blooded, cold stone-faced killer trying to portray himself as a hero instead of the cold-blooded, calculating killer that he actually is. Only a person with a severely diminished sense of heroism, with a heart that is cold as ice, can portray that. The absurdity of many of his words and I'll reference a couple. I wanted to make her death quick and painless. This is what he said. When I was listening to that, it was hard for me to comprehend that someone is actually saying that at their trial to a jury. Do we say thank you? I appreciate it. Thank you for taking my pain into consideration as you murder me? What does that even mean? Well, I'll ask you this. Was it quick and painless when he hit her in the head with a gun? Was it quick and painless when he stabbed her the first time? Was it quick and painless when he stabbed her the second time? How about the 5th? The 10th? Maybe the 20th? He was being considerate. Maybe the 30th? How about the final 35th blow? And then, of course, I asked him one question. How'd you drag her body across the room? And he said, I don't really recall, but I think it was by her ankles. And he looked me in the eyes in a stone cold faced way. Told me the answer. Like he was proud of it.
And? What?
He said, I do not want anyone else to be involved. I waited till everyone was gone. Thanks. Appreciate that. Talking like he's doing us a favor. I wonder what would happen if a neighbor did come over. I wonder what would happen if Brad Post had showed up. I wonder what would happen if Tina Parcell had showed up. Would it be a double homicide? So we could escape and escape detection? And of course, he was so calculated, he got her schedule that day from John Mello. And then he said, I didn't want to get caught because they would connect me to John Mello. Oh, okay. So If you didn't get caught, you've solved the custody problem. But if I did get caught, then I didn't solve the custody problem because then they would connect me to John Mello and he wouldn't get custody. Then he comes in here, testifies, connects John Mello. Doesn't make any sense. Now, he talked a good bit about his background. My understanding, he's a fantastic pianist, highly trained. But he went through his resume with an ego, letting you all know how great he really was. Military service. Playing these really difficult sonatas by Beethoven. I'm going to play all 16, never been done.
32, jerk off. Come on. I mean, like, I've been watching this trial
But he
for
described his sister Grace
a half a
in great
day.
detail as well, for some reason. He said she was a horrific person when confronted with irrefutable evidence. She would go cold, stone-faced. She would manipulate and recruit others to do a terrible deed. If you trust Grace, you're only going to get hurt again. She was a vampire and would suck the blood right out of you.
Glasses off.
Maybe he's describing himself.
Glasses on.
He said, I feel pity for her. He felt pity
Oh
for
my God.
Christina Parcell.
Glasses off.
How is that even possible of a human being? His heart
Glasses
was so
on.
mean, so depraved, that he viewed someone he'd never
Glasses
met
off.
and discussed the specific details of killing her, treating her like she was an elderly dog being sent to the vet to be euthanized. It doesn't get any meaner than that.
Yeah, they're definitely
Christina
reading
Parcell.
glasses. No question about that.
Didn't have to die.
Still,
Zach Hughes had a million opportunities to not do this. And if he did it to save Aida, there's a million ways to handle that.
he does look like Mr. Belvin.
Vigilante justice is not allowed in this state. Vigilante justice isn't allowed anywhere. Regardless of what Zach Hughes had in his mind or what he thinks he had into his heart, he's lying to himself. Because all he had was hate and meanness, coldness. He brutally murdered Christina Parcell. So, ladies and gentlemen, it's been a long 2 weeks. I thank you for your service, and I thank you for listening to me. The evidence is absolutely overwhelming. I'm going to ask you to go back there and deliberate. I'm going to ask you to find Zach Hughes guilty of harassment, of burglary, of possession of a weapon during the commission of a violent crime, and murder. Thank you.
May I please report?
Wow. That was we call that in the business a steaming pile of shit. That's what that was. The fact that he didn't even, like, I think he had to address the concept of jury nullification. He had to tell them, you must follow the law. Like he made the decision to, turn this dude into a straight up monster, which is an approach. But man, he's got to be able to read the room. And the fact that Hughes let slip about the evidence and the prosecution hiding it. I mean, he's relying on the fact that the jury is going to follow the judge's admonition as to that, and hoping that because the details didn't come out, that they'll just blow it off. Now, this is going to be an interesting closing because defense counsel here has to tread very, very carefully. He's going to stick to the script. He's going to stick to, as soon as he started hearing about Christine and what she was doing, he equated her exactly to who his evil adopted sister was. And that he tried to help. He tried to go through the proper channels and the system failed. And he was the last and greatest hope. I don't even know if he can get that in. Let's check it out.
Let me get a little bit more. Okay. I want to start with something that Mr. Wilkins said towards the beginning of his comments to you. He said, Zach Hughes solved John Mello's problems. Yesterday, Zach Hughes told you he solved Aida Mello's problem. That's what he told you yesterday. Ladies and gentlemen, you got to watch the state. You got to watch the evidence.
Leave him on.
Zach Hughes yesterday came in here and told you under oath that he killed Christina Parcell on October the 13th, 2021. He told you that. But contrary to what Mr. Wilkins just told you, killing somebody in and of itself is not a crime. Mr. Wilkins told you that he confessed to committing the crime. That is not the case. Yesterday, Zach Hughes told you that he killed Christina Parcell, but in doing that, he did not tell you or confess to any crime. And let me be clear, and let me tell you why I say that. Every crime, and the judge is going to tell you this in the instructions, every crime has two parts in general terms. The actus reus, which is the action, and the mens rea, which is what's in your mind, the intent that the state has to prove beyond a reasonable doubt. So it's very important that you understand this from the get-go. He did not confess to a crime yesterday. He confessed to killing Christina Parcell, but that in and of itself does not make him guilty of murder. That's very important, okay? The first part of, or Mr. Wilkins had talked about how this case is unique. It is unique. And one of the unique parts about this case is that first part that I talked about, the actus reus, the action that's involved, there's very little dispute, if any. Zach?
Well, Amanda, it's a good question. Isn't killing a crime? Not always. I mean, so he should be using the word homicide. Okay. Because the thing about homicides is homicides can be justifiable, which is not a crime. So not all killings are crimes. You have justifiable homicides. And for instance, self-defense, that is a justifiable homicide. So, but I'm not sure why he's not trying like that. I would have used the proper phrasing to the jury so they understood that concept. because I think Amanda's question is what a lot of people think. You know, I mean, Amanda is a potential juror in this world, you know? So it's like the clearer you can be with the jury in articulating the concept, the better.
Admitted that he killed Christina Parcell.
See, but the question, I don't think he has self-defense as was that barred as well? I'm under the impression, like, I don't see how he's going to argue that it's justifiable because defense of others gone. And from what I understand, self-defense is gone as well. Is that true? He can't, like, has both defenses been barred? Okay. So I don't even know how he's arguing this right now, to be honest with you. If both those things are barred, he cannot argue this was justifiable if neither of those affirmative defenses are available to him.
Right? Where the dispute is, where the heart of this case is the evidence as to what was in Zach's heart, what was in Zach's mind. The state must prove to you beyond a reasonable doubt. It must be evidence that leaves you firmly convinced. It must be evidence that would cause you not to hesitate to act. Right? That's what they have to do. So the heart of this whole case, Mr. Wilkinson can talk about the blood, he can talk about the scene, he can talk about all these things. But the heart of this case is the intent, is the mens rea. What have they proven about Zach's intent? All right. Now,
Flush it out, counselor.
What the judge is going to charge on the law and what they have to prove about intent, about the mental side of this. All right. Zach has been charged with murder. The state must prove beyond a reasonable doubt malice. That is the intent, the knowledge, the mental part of murder. The state must also prove burglary in the first degree, that when he entered that home, he intended to commit a crime. In this case, murder. He intended to commit the crime, which means there was a crime he committed. For harassment, the state must prove that he sent those mailers, which he admitted to doing. He sent those mailers without a legitimate purpose. And for the conspiracy, the state must prove that he formed an agreement to do something illegal. That is the mental component to this. And again, that's the heart of the case. And Mr. Wilkins, in his opening statement, said, we have to prove the state beyond a reasonable doubt an angry heart, that Zach was mad. That's where the heart of this case is. What was Zach thinking? What has the state been able to prove beyond a reasonable doubt about what was in his heart and what was in his mind? Now, you're going to hear, the judge is going to talk to you about different types of evidence you can consider. He's going to talk to you about circumstantial evidence, which is evidence that an arrangement of facts, when put together, that lead to other facts or conclusions. That's circumstantial evidence. Judge is also going to tell you about direct evidence. Direct evidence is evidence that comes from people who perceived what happened, who with their senses derived knowledge about what happened. All right, that is direct evidence. The state has the burden of proof on the mental element.
So, yeah, British Birdie, the jury might see his actions as somehow justifiable. There is a moral blindness when it comes to, look, here's the thing. That's not the law. It can't be justifiable if it's not self-defense or defense of others under the law. What you're talking about, British Birdie, is the concept of jury nullification, where the jury morally is not willing to follow the law and they acquit him in the face of violating the law. Because by like this malice argument, it's tough. It's tough. It's going to be a very difficult argument for him to make. I mean, he's stuck having to do it because he was handcuffed in terms of not being able to bring up what the real motive was. Like, he can't get into it. So, he's stuck having to say that, malice aforethought, that he went in with murder on his mind. I mean, he did. He wasn't going in there with the expectation of not walking out of there with her being alive. The intent was for him to go in there and he was going to walk out of that house and she was no longer going to be a threat to AM. That's malice aforethought. It just is. And because he can't get into the true motive in terms of what he knew about what was going on in that house with that child, he's really but he cannot argue. He cannot argue. He cannot argue jury nullification. He cannot tell them, hey, he's got to stay. Like, that malice argument is all he can do. That's all he can do. If he brings up jury nullification, it's a mistrial. You cannot ask a jury to ignore the law. You can't do it. It's forbidden. There's no loopholes. There's no ways around it. Straight up, if he argues or even intimates about jury nullification, that's available to them. Frankly, I'm shocked that the judge didn't declare a mistrial yesterday. I mean, the 6 months in for contempt, I'm trying to crawl into the judge's mind here. I'm still a little befuddled that the judge didn't allow the argument in. I think he should have allowed the defense of others' defense in. I really do. In light of what we know happened. Through actual evidence that's obviously not available to this jury, but that exists in the world. I mean, that's what I'm saying. This is a very, very delicate closing that this guy has to do right here. He has to be very, very careful with his words, because you know what he wants to say. We all know what he wants to be arguing, but he can't do it. Let's see how he does.
And the state is going to use circumstantial evidence. That's what they're going to use. We have no burden of proof whatsoever. We entered and are going to use both direct evidence and circumstantial evidence to explain what Zach's state of mind was on October the 13th, 2021. Now, what is the state going to do to try to prove what was in here, to try to establish the burden of the mental side? Again, it's more than just the acts. That's critically important. But what's the state going to use to prove the mental component to this? They're going to use the acts, and they're going to say, they're going to use the stab wounds, the photos. They're going to use all the actions that Zach testified to yesterday. That in and of itself is not a crime. And Mr. Wilkins, he talks about stab, and I wrote this down: stab, 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 slash. Right? Got to watch. Got to be careful. Right? This is a tragic case. Bottom line, someone died. The last thing I ever want to do is minimize the tragedy in this case. Not going to do it. All right?
Not going to do it.
When we come to talk to you about what happened, you have to have faith that what we are saying is balanced. Think about what Zach testified to and what Claire Rose testified to about Christina Parcell and what happened that day. All right? Stab, 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 slash, slash, slash. Claire Rose testified Christina Parcell was 163 pounds. Zach testified that he was 160 pounds. Claire Rose testified that there were, of the 35 wounds, the vast majority were incised wounds, superficial wounds, wounds that would have been consistent with a struggle. Zach told you that when he went inside, there was a struggle. He told you that they fell to the floor. He told you that when he got inside, his body would not do what he was telling it to do because he didn't want to do it. He did not want to have to do it. So let's talk about the circumstantial evidence that the state has offered as evidence to try to get you to understand what was in Zach's mind. The state talks about, and in determining how much weight to give to their representations about their conclusions on the circumstantial evidence, just think about this. Donna Gorman testified that 3 years after this happened, having never been shown a photo lineup, with Zach's face all over the television and the internet, that she says that she saw Zach. Now, here's what is most troublesome about this whole thing. She testified that she saw Zach at 8:15. That's what she testified to. She testified she saw Zach through 2 trees in her house, that he was wearing a hoodie, no evidence other than what she said about a hoodie. In back, Zach said that he was wearing a hat or a smaller hat.
Yeah, I'm going to have to go ahead and disagree with my esteemed friend and colleague, Josh, there. The state can absolutely, if there's something that destroys the ability to have a fair trial for the state, they can absolutely ask for a mistrial during trial. I mean, jeopardy attaches as soon as the jury is impaneled. So I'm going to have to agree to disagree.
There is no way that she could have seen Zach Hughes at 8:15, because by the state's own evidence, with the ring cameras, with investigator Sparkman, the state's own evidence, Zach didn't even get there until after 9 o'clock. So when he says, Donna Gorman, she saw him, it's impossible that she saw him the way she said, because she said 8:15 by their own admission, by their own evidence. Zach didn't even get there until after 9 o'clock. Think about that. In determining how much weight to give to their spin on the circumstantial evidence, think about investigator Sparkman, right? Called him as a witness and showed him reams of WhatsApp messages. These messages were garbled, but he had a unique skill. I don't know if he went to WhatsApp school, but he spoke fluent WhatsApp, right? And he was asked to decode all of these messages for you as though you couldn't have done it yourself. But what's the most interesting thing about what he said in the WhatsApp messages, there was one message that he was not able to decode, coincidentally. The message that had the words Aida and doomed. That was the only message he could not uncode for some reason. Think about that. In trying to determine how much weight to assign to the state's conclusions or their spin on the evidence, think about Vanessa Cormelo and what she testified to. Mr. Wilkins talked about how she was doing everything she could during this period to uncover it. Really interesting, and the judge is going to tell you this. You can determine or decide how much weight to give to testimony. You can give it a lot of weight, you can give it a little weight, you can give it no weight. I want you to think about how much weight to assign to the state's conclusions and that testimony, because I want to take you to one specific exchange between Jake Hofferth and Vanessa Cormelo. Jake Hofferth asked Ms. Cormelo, prior to October the 13th, 2021, and he said this, and they've said this throughout this entire case, prior to the murder of Christina Parcell, which is for you to decide and you to decide alone. prior to October 13th, 2021, did you have a recommendation as to where Aida Mello should live? In other words, would you have had a recommendation as to whether or not she lived with her mother? And what was Vanessa Cormalo's answer to that? And you can hear this for yourself. At the time, I would have recommended the mom. At the time. There was no follow-up to talk about other times. Can you trust that evidence? Very important. That's the circumstantial evidence. Now, let's talk about the direct evidence that you received from Zach himself as to why he did what he did. He got on that stand, he told you. Let's talk about the direct evidence. He talked about what he knew. What he was told by John Mello. That was part of it. He talked about that. But contrary to what Mr. Wilkins said, he had a lot of other information besides just what John Mello told him. He had a deposition that Christina Parcells gave under oath in July of 2016. And you remember I asked him, after you read that deposition, what did you believe about Christina Parcells? What did you believe? He said he believed that she was engaged in prostitution. He said he believed that she had participated in a pornographic movie. He said that he believed that she had used drugs after reading that deposition. Another document that Zach got, Alex Fields' affidavit. Now, this is very important to consider about this. This entire case, the state has worked very hard to distance Christina Parcells from the escort website. And they've made these conclusions just because they want to. Despite the fact that there are website addresses on those photographs, they have insisted that those photographs were private photographs, were taken by John Mello and then somehow put on the internet by John Mello, that she had nothing to do with that, right? Think about this. And this is an evidence for you to consider. The Alex Fields affidavit, it has one page on the front, which is what he said, that they met randomly at Halls in 2018, that she propositioned him for sex and drugs in exchange for money. He turned that down. But in the second page of the affidavit for Alex Fields, John Mello, in that advertisement, said, if you know this woman, her name is Christina Parcells, and then he puts the Caroline Warren alias in that ad. Right? Here's the question for you to consider. If he didn't think that she really and truly went by Caroline Warren online, why would he put Caroline Warren's name in an ad for people to respond to? Why would he include that if he did not think that may trigger someone who had seen her site? Why would he do that? I would submit to you, he put her name on that ad because she was Caroline Warren, and he was hopeful that someone who had seen the ad or used the ad would recognize the picture and contact him. That's the only reason why that makes sense. Let's talk about the other evidence, and let's talk about the elephant in the room. Let's just talk about it that Mr. Wilkins discussed. The planning, right? Let's talk about that. Zach was very honest when he testified about the planning. He told you in detail what he did. In a lot of cases, planning can be good evidence. In a lot of cases. As Mr. Wilkins said, this is a very unique case. And probably one of the most unique aspects about this case is that the person who Zach believed posed the danger was the mother to her own child. Think about that. This isn't where you're home and an intruder comes in, you don't know, and it's a spur of the moment. This isn't a random interaction or difficulty. This is what Zach believed. This is a mother, the person who's charged with caring for your child. Most importantly, the person of all on the whole planet who is supposed to be the most nurturing. This is the person who is doing this to the child. The person who lives with the child, the evidence was the person who shared a room with the child, the person who's with the child all the time. So in a situation like that, where you have a belief that's grounded on documents, that's grounded on information shared with you over many, many months, when you have that belief, how do you alleviate that threat, the threat from the mom, without thinking through how to do it? How do you do that? And so I would submit to you, ladies and gentlemen, that the planning in this case, unlike most any other case, doesn't show malice because the mom was the threat. The mom was the one who posed the danger. Mr. Wilkins talked a lot about this was just interjecting the custody, just get John custody, get him custody, all right? If this was all about the custody, why would Zach have waited so long to do it? Right? Part of it, he was in a process. Part of it, he was working on this music project. But the other part is Aida and John were separated for half a year. Right? If Zach wanted to fix it to solve John's problem, he would have done it much sooner. But the reason why it took so long is that Zach agonized over it. What do I do? Over time, he continued to get information. What do I do? He didn't want to do it. If he wanted to do it, he would have done it right away. And he told you that when he testified. He told you in detail about that day. He told you about it. About when he woke up, he drove to that location and he thought he was going to throw up. He told you about his hand shaking. He told you about when he got out and got on his bike, it was one pedal in front of the other, just trying to make it there. He told you about this, and you saw him testify. He's, contrary to what Mr. Wilkins said, he doesn't think he's a hero. He's never asked that. He did what he believed he had to do to save an innocent child. That's what he did. That's why it's more than just the action. He hasn't confessed to any crime. He told you what he did. And he told you the truth about what he did. If Mr. Wilkins talked about solving John's problem, right? And he intimated in his closing that an aspiring or starving, I can't remember what word he used, pianist would turn down $10,000. Interesting. As though to say he didn't turn it down. There's no evidence anywhere that John Mello ever paid him a dime to do this. None. Gotta watch the state, ladies and gentlemen. In the state's closing, lot of moral indignation. That, what do you mean try to be humane? Who can say that? How does that even mean, right? I was not in Zach's shoes. Nobody was in Zach's shoes but Zach. Nobody was. None of us has been in a circumstance where we have reason to believe an innocent child is being abused by her own mother, where her father is out of the country, the evidence is shown, with a warrant pending, can't come back. When you write an affidavit to try to put the authorities on notice as to what you believe is happening, when you call DSS and DSS does nothing, none of us have been presented with that circumstance. Mr. Wilkins said, we can't condone vigilante justice. That's what he said. He said, if you find him not guilty, I'm going to be out of a job. Right? It's really interesting. The state wants you to be a legislature and make decisions for the people of the state in law and order. But they don't want you to be a jury when it comes to deciding how the law applies to the facts. Because they just want you to assume he's already confessed to it, he's guilty of a crime. They use the word murder throughout, which is a legal phrase, which is an offense that you have to find. So they want you to speak for the people of the whole state, but they don't want you to really look at the evidence. And that's what we're asking for. That's just what we're asking for. Mr. Wilkins said he could have done other things. This didn't have to happen. Okay? The judge will not instruct you that Zacahry Hughes had a burden to exhaust all remedies, to try everything he could to do. He tried a lot. He wrote the affidavit, went to DSS, did a lot of different things. But there's absolutely no requirement. We have no burden whatsoever. Just to continue to remind you that. We have no burden whatsoever. The burden is on the state. And there's no burden whatsoever for me as Zacahry Hughes' representative to try to prove to you that he exhausted every remedy. That's just not what the law says, and you don't need to prove. You don't need to even consider that. The evidence is that Zach tried. And when everything failed, that's when he acted to do what he thought was right, and that is, and was, to save Aida Mello. Ladies and gentlemen, the state talked about the mailers, and I don't envy your task. I don't at all. It's a tall task. But I do think the mailers, this piece of the case is a little bit easier for you to resolve, and let me tell you why. The judge is going to tell you that for it to be harassment, a couple things have to happen. First, the person who was the target of the harassment, in this case, Christina Parcell, who's alleged in the indictment, the state must prove beyond a reasonable doubt that she actually suffered mental distress, and that a reasonable person would have done so in that circumstance. But there has to be evidence that she actually suffered distress, mental distress. There is almost zero evidence that she actually experienced mental distress in this case, right? Let me talk more about that in specifics. There were at least 3 people who testified for the state who were with her when she gave the letters, those envelopes to law enforcement. At least 3 people: Brad Post, Dan Bevel, Mike Nicholson. Did any of those people testify that she was remotely upset? Any of those people say that she cried? Any of those people say that she was shaking? Any of those people say that she had made statements that led them to believe she was upset? Zero evidence that shows, or that even comes close to proving, that Christina Parcell was upset. And if anything, the evidence you've seen that has been introduced with nude photos of Christina Parcell online, with Alex Fields' affidavit, I think the evidence shows took a lot to get her upset. or be in mental distress. So I would submit to you, ladies and gentlemen, on the harassment charge, that's something that you could go to initially and think about that evidence. And based on your recollection of the evidence, if you find that there's no evidence to prove beyond a reasonable doubt that she was in mental distress, then that's your answer on that charge right there. It's the state's burden of proof on each and every element. Ladies and gentlemen, in conclusion, the state has brought us here. And they brought the charges that you are to consider. They've decided what to charge, and they have brought us here on these specific charges. And the charges they brought, specifically the charge of murder, is among the most serious charges there is. Doesn't get any more serious than that. Murder, the charge of murder, in contrast to what the state's position is, requires more than the act of killing another person. It requires malice. Malice is defined, and the judge is going to define this for you, as evil, as hatred. In his opening statement, Mr. Wilkins told you an angry heart, mad. Ladies and gentlemen, I would submit to you that the evidence in this case has failed to show you that you should be firmly convinced that Zacahry Hughes had hatred. You can be shown pictures and talked all about the acts, but when it comes to what he was thinking, what the evidence shows that was in his heart, that evidence hasn't come close. Ladies and gentlemen, in hindsight, 3 years after this happened, it's very fair for you to say this didn't happen, or this didn't have to happen, or disagree, I wouldn't have done that. Some of you may say you would have, some of you may say you wouldn't. That's fair. Bottom line. Can't say otherwise. But no matter what your take on what he did, I think it's so important that we rely on your common sense. And that was one of the things that Mr. Wilkins talked about early on, that how important your common sense is that you bring with you. And so in closing, I'm going to ask that you use your common sense that you brought with you to the courthouse and just ask yourself, does a person who kills another person with the intent to save an innocent child, does that person have evil in their heart? Does that person have an angry heart? Ladies and gentlemen, I would suggest to you that your common sense would tell you no. And that person who killed another to save an innocent child.
Ooh, he tried to slip it in there. He tried to slip it in there. Ooh.
I would ask that you return a not guilty verdict. Thank you very much.
See how he tried to slip it in there? They killed another. Boy.
Now the state has an opportunity to rebut, and I promise you, ladies and gentlemen, I'm going to be brief, so y'all can get to your deliberations. I do want to address a couple of issues. I want to make very clear, in this record, there is zero evidence of any kind of abuse. Not for a witness, not from any evidence. Mr. Mormon said you got to have some emotional distress from the harassment charges. Christina Parcell had a bunch of neighbors receive pictures of her without clothes on, private photos between her and John Mello. And so what did she do? Immediately, well, Brad Post corralled them all up, took some from neighbors so they didn't see them, and she went to the police. Going to the police without emotional distress, it's not something that you see very often. Mr. Mormon talked about not trying to minimize this case. Minimize the killing of Christina Parcell. Minimizing the heinousness of this crime while trying to impugn her character. He talked about malice, and he said that you got to have an angry heart. He kept referring to me. I said, an angry heart, malice. You're mad at somebody. And I'll leave you with this. Ladies and gentlemen, regards to an angry heart, just because Zacahry Hughes' heart is so cold and so dead that it can't be angry, that is not a defense. You prove it by his actions. Thank you.
Wow. I don't know. I don't know what you all think, but both closings have left me wanting. The jury's got to be sitting there like, what the hell? Like what the hell? So I looked up. This is now, I don't know if they have a specific malice definition instruction, but it's important because, as I've told you, in this attorney, you have to prove each and every element of the crime. So in South Carolina, they say that state law utilizes malice aforethought to define the mental state the defendant had at the time of causing someone's death. If a prosecutor fails to prove the defendant premeditated hostility against the decedent, the charges may be acquitted. Several different mental states may qualify as malice aforethought, including specific intent to kill a person, intent to commit a felony, intent to cause grievous bodily injury, reckless indifference to life, and a preconceived plan to kill a person. I'm sorry, but under those definitions, all of those apply, that malice aforethought has been shown here. I mean, he went in for one reason and one reason alone. It wasn't to confront her. It wasn't to grab AM and run. It was to end her life. So I don't know. Had they been able to get that, like it's tough how a jury is going to be able to get to jury nullification unless they really are thinking about what he said about the abuse, and that but if you have one juror back there, like say for instance, the foreperson is like, look, I heard what he said. I heard that they're hiding stuff from us. I heard that there was abuse of the child. I heard it, but the judge said we can't consider it, so we can't consider it. So that could be the debate back there. I mean, if you had enough people that were able to read through the tea leaves and come up with, well, he did this to save the girl, I can't do it. I can't convict him. I mean, you could have a battle back there, or this thing could come back in an hour where they're like, what the hell have we been here for 14 days for? This guy admitted he killed the kid. Like, why are we here? Like, I don't see what the defense is. So we'll see. It'll be interesting. Closing's underwhelming, in my opinion. Very underwhelming.
Members of the jury, it is now my duty as the trial judge to instruct you on the law applicable to this case. And in that regard, it is your duty as jurors to accept and apply the law as I'm now stated to you. Furthermore, it is your exclusive duty to decide all the issues of fact in this case and determine the effect, the value, the weight, and the truth of the evidence. All the parties have the right to expect that you will carefully consider and evaluate the evidence and apply the law of the case to it so that in the end, all parties will receive a fair and an impartial trial. I remind you that during this trial, you and I have certain duties to perform. As the trial judge, it is my responsibility to preside over the trial of this case, and I also have the duty to rule on the admissibility of the evidence offered during this trial. You are to consider only the competent evidence before you. If there was any testimony ordered stricken from the record during this trial, you must disregard that testimony. And furthermore, you should not even mention or discuss any testimony that I've instructed you to disregard in the deliberation room. You are to consider only the testimony which has been presented from this witness stand, any exhibits which have been made a part of the record in this case, and any stipulations of counsel. I have the additional duty to charge you the law applicable to this case. As the presiding judge, I am the sole judge of the law of this case, and it is your duty as jurors to accept and apply the law as I now state it to you. If you already have any idea as to what the law is or what the law ought to be, and it does not agree with what I now tell you the law is, you must abandon this idea because you are sworn to accept the law and apply the law exactly as I state it to you. In every case tried in this court before a jury, the jury becomes the sole and exclusive judge of the facts in a case. A trial judge cannot intimate, state, comment on, or make any statement to a trial jury about the facts in a case. Since you, the jury, are the sole judge of the facts in this case, you are not to infer from what I've said during this process or during the progress of this trial in ruling upon the admissibility of evidence or otherwise, or anything that I say now during this course of this instruction to you, that I have any opinion about the facts in this case. The law does not allow me to have an opinion about the facts in this case. This is a matter solely for you, the jury, to determine. And as jurors, it is your duty to determine the effect, the value, the weight, and the truth of the evidence presented during this trial. The defendant is charged with the following: murder, possession of a weapon during the commission of a violent crime, burglary, first degree, conspiracy, and harassment, first degree. I remind you that the fact the defendant was arrested, charged, and indicted in this case is not evidence in this case and cannot be considered by you as evidence of guilt in this case, nor does it create any presumption or inference of guilt. These documents are simply the formal instruments which contain the charges made against the defendant. It is the formal documents by which this case is brought into this court. The indictments in this case allege several different offenses against the defendant. Each indictment charges a separate and distinct offense, and you must decide each indictment separately on the evidence and the law applicable to it, uninfluenced by your decision as to any other indictment. The defendant may be convicted or acquitted on any or all of the offenses charged. You will be asked to write a separate verdict of guilty or not guilty for each indictment. The defendant has pled not guilty to these indictments, and that plea puts the burden on the state to prove the defendant guilty. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent. I charge you that it is an important rule of the law that the defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until and unless you reach a verdict of guilt based on evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is not mere legal theory, and it is not just a legal phrase. It is a substantial right to which every defendant is entitled unless you, the jury, are satisfied from the evidence of the defendant's guilt beyond a reasonable doubt. The state has the burden of proving the defendant guilty beyond a reasonable doubt, and some of you may have served as jurors in civil cases where you were told that it is only necessary to prove that a fact is more likely true than not true, such as by the greater weight or preponderance of the evidence. In criminal cases, the state's proof must be more powerful than that. It must be.
What happened? Oops. I think I paused
Beyond
it.
a reasonable doubt. A reasonable doubt is the kind of doubt that would make a reasonable person hesitate to act. Proof beyond a reasonable doubt is proof that leaves you firmly convinced
Whole time.
of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you're firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. If, on the other hand, you think there's a real possibility that the defendant is not guilty, you must give the defendant the benefit of the doubt and find him not guilty. Facts and circumstance that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the accused. Facts and issue may be proved either by direct evidence or indirect evidence or circumstantial evidence. It is direct evidence if it proves a fact without an inference, and which in itself, if true, conclusively establishes that fact. Direct evidence is basically evidence you can see, observe, or hear with your senses. Circumstantial evidence means the proof of a chain of facts and circumstances indicating the existence of a fact. In other words, you may infer that a particular event occurred based on proof of circumstances warranting such an inference. It is not something that one observes, but from facts, one can draw a conclusion. Crimes may be proven by circumstantial evidence. The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, all of the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof has failed. The state has the burden of proving the defendant guilty beyond a reasonable doubt. The burden rests with the state, regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. The following things are not evidence, and you must not consider them as evidence in deciding the facts of this case. 1, statements and arguments of the attorneys. 2, questions and objections of the attorney. And 3, testimony that I instruct you to disregard. While argument of counsel is a beneficial part of every trial, you should remember that the statements made by counsel are not evidence. In presenting arguments, counsel often refer to evidence. However, you should base your verdict on the evidence as you remember it. Therefore, if there are any conflicts between the recollection of counsel about the evidence and your own recollection, you should rely upon your own understanding of the evidence. Necessarily, you must determine the credibility of witnesses who have testified in this case. Credibility simply means believability. It becomes your duty as jurors to analyze and to evaluate the evidence and determine which evidence convinces you of its truth. In determining the believability of witnesses who have testified in this case, you may believe one witness over several witnesses or several witnesses over one witness. You may believe a part of the testimony of a witness and reject the remaining part of the testimony of that same witness. You may believe the testimony of a witness in its entirety or reject the testimony of a witness in its entirety. You may consider whether any witness has exhibited to you any interest, any bias, prejudice, or other motive in this case. You may also consider the appearance and manner of a witness while on the witness stand. The rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions, and an exception to this rule exists for witnesses we call expert witnesses. A witness who by education and experience has become expert in some art, science, profession, or calling may state an opinion as to relevant and material matter in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received in evidence in this case, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert witness is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of other witnesses simply because the witness is an expert. Further, you are not required to accept an expert's opinion, even though it's not contradicted. There's been evidence presented that witnesses have made prior statements which are not consistent with the witness's present testimony. You may use this evidence to decide whether to believe the witness. You may also use evidence of the earlier contradictory statements to determine the truth of those statements. It is up for you to decide whether to believe the earlier statements or the testimony given at trial. If a witness is shown to have knowingly testified untruthfully concerning any material matter, you may consider this in determining whether to trust the witness's testimony as to other matters. You may reject all testimony of that witness or give all or part of the testimony the weight you think it deserves. In order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt, and criminal intent is always a matter that must be determined by the jury from the circumstances surrounding the situation. There's no way to prove intent to a mathematical certainty. There's no way medical science can dissect a person's brain and determine what the person had in mind. So the law says that criminal intent may be inferred from the circumstances shown to have existed. And this is how you make a determination of whether or not the elements requiring intent was present. It is not necessary to establish intent by direct and positive evidence, but intent may be established by inference in the same way as any other fact, by taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state, a conscious wrongdoing. It is up to you to determine what the defendant intended to do based on the circumstances shown to have existed. Criminal intent can arise from action or a failure to act. It may arise from negligence, recklessness, or an indifference to duty or to consequences that is considered by the law to be the equivalent of criminal intent. The defendant is charged with murder. The state must prove beyond a reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular length of time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be either expressed or inferred, and these terms express and inferred do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, any acts of preparation
Ooh.
going to show that the deed was
There's the
within the
problem.
defendant's mind would be express malice.
That's a problem.
The defendant is charged with possession of a weapon during the commission of a violent crime, and the
That's why this case, it can only be jury nullification. I mean, that malice, if that doesn't make it clear to you, it was premeditated. He planned it. It's malice. So the only NG in this case is straight up jury nullification. This is either going to be a very, very quick verdict, or you're going to have a war back there.
state must prove beyond a reasonable doubt that the defendant was in possession of a firearm or knife during the commission of a violent crime. A firearm means any machine gun, automatic rifle, revolver, pistol, or any weapon which is designed to or may be readily converted to expel a projectile. In order to find the defendant guilty of possession of a weapon during the commission of a violent crime, you must first find the defendant guilty of committing a violent crime. Murder is a violent crime. The state must prove beyond a reasonable doubt that the weapon furthered, advanced, or helped in the commission of the crime. The defendant is also charged with first-degree burglary. The state must first prove beyond a reasonable doubt that the defendant entered a dwelling without consent. A dwelling is any building or portion of a building in which a person ordinarily sleeps. A building is a dwelling even if the residents are temporarily absent from the building. In order to prove that the defendant entered the dwelling, the state does not have to show that the defendant's entire body entered the dwelling. The smallest entry is sufficient. It may be any part of the body, such as a hand or foot, or even an instrument, such as a hook or other instrument. In addition, the state does not have to prove that force was used to gain entry. If a person enters a building by using deception, artifice, trick, or misrepresentation to get consent to enter, this is an entry without consent. Next, the state must prove beyond a reasonable doubt that the defendant intended to commit a crime, either a felony or a misdemeanor, at the time of the entry. The mere entry into a dwelling without consent is not burglary. If the intent to commit a crime is formed after the entry, it is not burglary. On the other hand, if the defendant intended to commit a crime at the time of the entry, it is a burglary, even if the intent was abandoned after the entry. It does not matter that the intended crime was not completed. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. Finally, the state must prove beyond a reasonable doubt the existence of one of the following aggravating circumstances, such as 1, when entering while in the dwelling or in immediate flight, the defendant or an accomplice caused physical injury to anyone not participating in the crime, or 2, when entering while in the dwelling or in immediate flight, the defendant or an accomplice used or threatened to use a dangerous object, or 3, when entering while in the dwelling or in immediate flight, the defendant or an accomplice displayed what was or appeared to be a knife, pistol, revolver, rifle, shotgun, machine gun, or other firearm, or 4, when entering while in the dwelling or in the immediate flight, the defendant or an accomplice was armed with a deadly weapon or explosive. A deadly weapon is any article, instrument, or substance which is likely to cause death or great bodily harm. Whether an instrument has been used as a deadly weapon depends on the facts and the circumstances of each case. The following are examples of instruments which may be deadly weapons: a pistol, A shotgun, a rifle, a dirk, a dagger, a knife, a slingshot, metal knuckles, a razor, gasoline, a firebomb, Molotov cocktail, and lighter fluid. A gun may be a deadly weapon, even if it is not operating. The defendant is charged with conspiracy. The state must prove beyond a reasonable doubt that the defendant combined with one or more persons for the purpose of committing an unlawful act or of committing a lawful act by unlawful means. There must be a mutual understanding, agreement, or common intention and plan. Mere passive knowledge of or consent to the criminal conduct of another is not enough to make a person a conspirator. There must be guilty knowledge and participation. Similarly, the mere fact that the defendant may have associated with another person or met with another person and discussed common aims and interests does not necessarily establish proof of the existence of a conspiracy or that the defendant was involved in a conspiracy. On the other hand, it is not necessary that the agreement be a formal one, that it be in writing, that the person hold a meeting and expressly state in the terms of the common plan, or that the agreement be stated in words between them. The agreement of a criminal conspiracy may come into being through an implied mutual understanding. The willful, intentional, and knowing adoption by two or more persons of a common plan is sufficient. No overt acts need to be shown to establish a conspiracy. A conspiracy may be shown by circumstantial evidence and the conduct of the parties. In order to convict the defendant of conspiracy, the state must prove beyond a reasonable doubt not only that the defendant knew of the unlawful conduct, but that the defendant agreed to combine with the other person for the purpose of accomplishing the unlawful conduct. The defendant is charged with harassment first degree. The state must prove beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntary. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment first degree by showing that the defendant engaged in a pattern of 1, following the targeted person as the targeted person moved from location to location, 2, initiating, maintaining, or repeating visual, physical, or verbal contact after the defendant was notified that the contact was unwanted, 3, surveilling or the maintaining a presence near the targeted person's residence, place of work, school, or another place regularly occupied by the targeted person, or 4, committing vandalism and property damage. These are only examples of harassment first degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment first degree. A pattern means 2 or more acts occurring over a period of time, however short, evidencing a continuity of purpose. If you find the defendant not guilty of harassment first degree, you may consider whether the defendant is guilty of harassment second degree. A defendant is guilty of harassment in the second degree if the state proves beyond a reasonable doubt that the defendant engaged in a pattern of intentional, substantial, and unreasonable intrusion into the private life of a targeted person that served no legitimate purpose and caused the targeted person and would cause a reasonable person in the targeted person's position to suffer mental distress. Intentional means willful, intending the result which actually occurs, not accidentally or involuntarily. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state may prove harassment second degree by showing that the defendant engaged in a pattern of verbal, written, or electronic contact that is initiated, maintained, or repeated. These are only examples of harassment second degree. You may find that other conduct of the defendant which caused the targeted person mental distress would be harassment second degree. A pattern means two or more acts occurring over a period of time, however short, evidencing a continuity of purpose. Electronic contact means any transfer of signs, writings, images, sounds, data, intelligence, or information of any nature transmitted in whole or in part by any device, system, or mechanism, including, but not limited to, a wire, radio, computer, electromagnetic, photoelectric, or photo-optical system. In determining the guilt or innocence of the defendant, you cannot consider any possible penalty for any particular crime. The punishment for the crimes is a matter for me to determine and should never be considered by you in any way whatsoever in arriving at an impartial verdict as to the guilt or innocence of the defendant. Madam Foreperson, and ladies and gentlemen of the jury, I wish to express the hope that each of you will be mindful of the importance of your responsibility. You're not called upon to serve as jurors very often, and the proper performance of the duty requires each of you to reach the height of freeing your mind of all improper influences. As the presiding officer of this court, I am vitally concerned that whatever verdict you find will be the result of your going into the jury room and confining your consideration to the evidence and the law that you have heard in this courtroom, weighing it fairly and impartially, as I have every confidence you will do. Your verdict in this case cannot be based on sympathy, compassion, prejudice, or emotion, or some other consideration not found in the evidence. Remember, your verdict must be unanimous. I will now explain the verdict form and possible verdicts. There are 2 pages to the verdict form, and this will go back with you to your jury room. Once you have received that, you'll be instructed at that point to begin deliberation. There are 2 possible verdicts for each charge, which you may find in this case, and there's no significance whatsoever in the order in which I state these possible verdicts. It is simply that one must be stated first. Ladies and gentlemen, your verdict must be a unanimous one. Madam Foreperson, when the jury agrees on the verdict, you will write the verdict on this verdict form and then sign your name as Foreperson. Then knock on the jury room door and inform the bailiff that you have reached a verdict. At that time, we will receive you back into the courtroom. Madam Foreperson, if the jury has any questions, please write the questions on a piece of paper, not the verdict form, and give to the bailiff. Everyone needs to be present when deliberating. If one of you takes a restroom break, then the rest of you should pause deliberations until said person returns. I ask that you now return to your jury room, but do not begin deliberations until you are told by the clerk or the bailiff to do so. There are matters that I must discuss with the attorneys before you begin your deliberations, and if my 4 alternates will remain in the courtroom.
All right. There we go. There we go. So vast majority. We got a poll of 85% guilty, 15% not guilty. It's going to be a tough road to hoe back there. I tend to think that this case is very much going to live in the appellate courts. It'll be interesting to see what they do, because ultimately the issue for the appellate courts is, was the judge incorrect in barring the defense of others from coming in? Because if they're allowed to bring the defense of others in, they're going to be allowed to bring in all of the other stuff, all of the bad acts, as to why he went in there feeling the way and acting the way that he did. So, I mean, that's what I think will happen. I don't know. I think this is going to be a very quick verdict. I don't think that the jury got enough. Like, you guys, they don't know what y'all know. You know what I mean? They just don't know it. So, and the bottom line is, um, they weren't given the opportunity to ponder defense of others. So Afton asked, for a defense of others, would he have to prove what he knew and when? Uh, because it's different. It's different. Like, it is an unusual case. A lot of defensive other cases, like, are in the moment type situations where you see something taking place and you intervene. It's a longer road. I mean, he learned of this abuse that was going on. But I mean, there's a clear paper trail. I mean, this guy tried to do things that were within the system. I mean, he wrote letters. He created affidavits. It's not as if this guy just went off half-cocked. I mean, he tried to work through the system. Telling you, if they can get that defense in, this is a much, much harder decision to make for a jury. Just is. Because there's going to be like when the jury starts seeing the abuse that this child suffered, I mean, good luck, state. Good luck. And if the jury has their ability to hang their hat on something and find that it was justifiable, I think that they will. I mean, this child suffered. This shit sounds insane to me. So, all right, here's what I'm gonna do. We will keep an eye on. So we're officially on verdict watch. I think they went back about 5 minutes ago, so 2:50. Unfortunately, our tech wizardry has not allowed us to have a verdict clock. So I'll start my stopwatch because I'm old school on my phone, and I'll keep track that way. All right. Oh, I was in the middle of penning a furious Twitter reply to a troll. Exhausting. It's so exhausting. So very exhausting dealing with the trolls. I just don't get it. All right. So what I'll do, we will be on verdict watch. If this thing comes back imminently, we'll jump back on. So make sure you hit your notifications. Please do me a favor, hit the like on the way out. Make sure you share, subscribe. Thank you for everybody's generosity, everybody you gave. I think I got you all up on the screen. I think I answered all the questions, I hope. Thank you once again, Afton, for paying to tell me I was muted. It's the longest con in the world, twice, no less. I appreciate you mods. You guys are amazing. I appreciate you guys for hanging with us. And no notice. And remember, tonight, whether we get a verdict or not today, Runkle. It's Runkle time, baby. It's Runkle. Runkle of the Bailey. It's going to be here hanging with us, making us laugh, making us think, all the things that come along with Runkle. His glorious locks flowing in the air. I've asked him to have a fan blowing in front of him so that his hair is constantly whipping gently in the wind. It'll be fabulous. I anticipate it'll be a great live. I really hope that Allie can join us. She just left for the doctor, so Allie never gets sick. Allie never gets sick. So please, y'all, hit your notifications. If you haven't, give us a sub. Give us a sub. If you really love us, become a member. We gifted 5 out today, so I know we got a few new ones in. We love having the fam. We love the community. You're the best in the business. I'll put you up against anybody. I know there's so many bleed overs with my friends, with Josh over at Courtroom Confidential, with my boys Publicly Buzzed, with Steve and Dan, with all my homies. I think we're all creating an amazing community. And yes, absolutely, the Grizzlies. Gisela is wonderful in so many ways. Yeah, we do, Cyan, but I don't think I think she picked something up in Florida in God's waiting room down there. She came back with this like cough, and then it's gotten progressively worse. I love the Grizzlies more than they love this channel. And G. I think she's fabulous in every single way. I love her. She got scared off from putting me on the show because I was so deep into the Delphi shit, and she got sick of dealing with the abuse. I told her, I'm like, I get it. I get it. I'm like, bring me on. We'll talk about the Gacy shit. I could blow people's minds over in Grizzly World with the Gacy stuff. Tell you that. So, all right, you guys are the best, because without you, I'm just an old man talking about a bunch of cases. Talk to you later. Bye.